Hear you. The Court of Appeals of the State of Michigan is now in session. The Honorable Mark T. Boomstra, the Honorable Adrian N. Young, and presiding the Honorable Christopher P. Yates. All persons having business in the hearing draw near, give attention and shall be heard. God save the United States, the State of Michigan, and the Honorable Court. Please be seated.
Good morning, everyone. Welcome to our first day of case call, which uncharacteristically is on Thursday. But look on the bright side, you don't have to come in on Friday and sit till the afternoon. We are panel 6. I'm delighted to be sitting with my colleagues, Judge Boonstra and Judge Young today. We have a long call, 14 cases today. And so those of you who are early are fortunate. We have no idea how long this may go, but we're here for the duration, and we look forward to hearing what you have to say. Let me just offer a few comments before we get started. First of all, you have a half hour per side if you are opposed, 15 minutes if you're unopposed. And I think we just found out this morning that somebody went from opposed to unopposed. So I'm sorry, you lost 15 minutes in the exchange. But for the rest of you, we look forward to hearing your arguments for as long as you'd like to go. But please understand that we're well prepared and we don't need to hear the facts. Just jump right into your arguments and we'll be glad to join you where you start. I just want to say a couple more things because these arguments are broadcast, they're live streamed, and they're archived. So if you're talking about any minor children, please do not use names. Please use initials only. We have a large number of cases involving termination of parental rights and also some cases with some younger victims. So please be careful about that. And if you have more than one person arguing on a side, tell us how you want to divide up your time. We'll be glad to honor that and I'll help you keep track of it. Finally, if you want some time for rebuttal, let me know. I'll be glad to make sure you stop in time to save yourself a few minutes for rebuttal. With that, I think we're ready to start the call. Let's begin with case number 1, docket number 371057. It's the matter of the People versus Robert Anthony Carter Carr II. And we have Mr.
I don't see Mr. Simon.
All right, we had Mr. Simon endorsed. We'll see if Mr. Simon appears, but for the time being, we'll let this one go. Let's move on to case number.
Sorry, judges, this is the clerk's office. Mr. Simon is actually in the remote gallery.
Oh, okay.
I don't see that he's filed a request for this case, but I can put him in if you need.
Well, yeah, why don't you put him in and let's see what he has to say for himself.
Thanks.
Good morning, Mr. Simon. How are you? Can you hear me?
Yes, Judge, I can. Thank you. I'm sorry I'm late. I couldn't find the link. But I'm here now. And I know that people are not endorsed, so my comments will be very brief.
All right. Well, let me put it this way. Although I don't know that we authorize you to appear remotely, we're perfectly happy to hear from you. So why don't you tell us whatever you want to say? I don't think you have an opponent here, so you don't have all that much time, but we'll be glad to hear anything you want to tell us about Mr. Carter Carr.
Only that when the jury was told it would take 2 weeks to get a transcript, I think that's in essence foreclosing a transcript request. And I believe that that was a denial on which was inappropriate and in violation of the rule. For that reason, we're requesting a new trial. In the alternative, argument 2 basically requires in a case involving a complainant less than 13 and a defendant 17 or over, for the jury to make special findings as to the respective ages of the two. They were not asked to do so. And so for that reason, we don't believe Mr. Carter Carr should be subject to the 25-year mandatory minimum.
Sure. But just to be clear about this, I don't think there's any doubt whatsoever that the victim was under 13 and that Mr. Carter Carr was significantly older than 17. Is that right?
Well, that was the testimony, but the jury is also instructed that they can believe everything witnesses say, they can believe nothing witnesses say, or they can believe part and disbelieve other parts. And so I think in order to impose the 25-year mandatory minimum, it was incumbent to make the jury make these special findings, which are part of the what should have been the verdict form. And there is a verdict form which does require those special findings, which has been approved and should be used in these kind of situations. And it was not. It was strictly a guilty, not guilty situation without the special findings. I don't believe that the court was in a position to assess the mandatory minimum.
And Mr. Simon, my understanding of the verdict form is that it did have in parentheses, person under 13, defendant 17 years of age or older, but you're saying that that's not specific enough.
No, there is a form which has been approved for this purpose, and it does require special findings as to the age of the complainant and as to the age of the defendant. And without those special findings, the general verdict form doesn't allow for the finding, because there could be a finding that yes, there has been a penetration, but not as to age. And the jury, certainly there was some confusion. They'd asked for transcripts. They wanted more information. We don't really know exactly what it was that they had an issue with, but we certainly know that they were not permitted to look at the transcripts to resolve whatever concern that they had after being told they had to really have to wait 2 weeks for a transcript. And so I think that we cannot rely on the words over 13, under 13, over 17 on the verdict form, because it's not in the appropriate fashion. It doesn't require special specific findings as set forth in the appropriate form.
Anybody else have any questions? Thank you very much. Well, thank you, Mr. Simon, for appearing this morning.
Thank you, and I apologize. I thought I was approved for oral Zoom, but if not,
Don't worry about it. Please don't worry about it. It's perfectly fine. We were glad to see you and glad to hear from you this morning, sir.
Thank you, Judge. I'm glad to be here, and take care and happy holidays.
Thank you so much.
Wow.
That case will be submitted. We'll now move on to case number 2, People versus Isaiah David Evans. This is case number 371196. And we have a couple of updates on this case. First of all, for the appellant, we've been notified that Ms. Teratuda has waived oral argument. So for better or for worse, I think we have a law student who's going to argue today. So would somebody like to introduce him?
Your Honor, Grant Hoffman, and the Chief College of Law Public Defender Clinic. I'm actually joined by 2 students. Maggie Rose, a third-year law student, who will be arguing the case today. And to my right is Mason Knowles, who is past the bar and practicing at the Eaton County Public Defender Office.
Oh, wonderful.
Joining us to see co-author briefing.
Oh, congratulations. All right. Well, first of all, thank you, Mr. Hall. Second, Mr. Rhodes, you are welcome to come to the lectern. And I want to thank you not only for taking on this responsibility, but also for your courage appearing right before final exams. I can only imagine that the timing was not ideal.
But you've already scared off your opponents, so you're doing well.
Yeah, right.
That counts for something.
So you find yourself in the enviable position of being the appellee. So you're just trying to convince us to do what the trial court did, and you have nobody to argue the other side. We'd be glad to hear anything that you want to say, because I'm sure you're well prepared.
May I proceed?
Yes, you may proceed. Thank you.
Good morning, Chief Justice, Associate Justices, and may it please the court. As you previously heard, my name is Nigel Rhodes, and I'm here today on behalf of Michigan State University College of Law Public Defender Clinic, representing Isaiah Evans. The diligent standard exists to protect judicial efficiency and to allow trial courts to control its dockets. Reversing the trial court's decision would negate that protection and undermine all trial courts' ability to control its dockets.
Mr. Rhodes, how long was this case actually on the docket? I know it was years, but how many?
I can only give you, Your Honor, years. I know that, the preliminary exam was back in February of 2020. And by the time we get to April 29th of 2024, that's when the trial court in this case.
So in other words, more than 4 years.
Yes, 4 years, which is more than enough time for the prosecution in this case to be able to get their witnesses pursuant to MCR 2.503C2 available. Now, keep in mind, Your Honors, the prosecution had 3 bites at the apple. And in between trial dates 2 and 3, which is May 2nd, 2023, and April 29th, 2024, respectively, there is a key hearing, actually two key hearings in between trial 2 and trial 3. And so when you go from May 2nd, 2023, which was trial 2, the trial court actually gave like a small 4-week adjournment to June 2nd of 2023. The prosecution in this case decided to forego trying to find the forensic scientists because of the turkey hunting and decided to try to retest the narcotics in this case. And so we are in this June 2nd, 2023 hearing, and the prosecution didn't have the lab results. And so it was during this hearing where the trial court said, okay, I have my docket being backed up. I have to cram all these pretrials. And both parties agreed that this trial would be no more than 3 days. So this is significant because this is the court communicating to the prosecution that we have to go into 2024 because my docket is being backed up. And then the court, even after admitting that it's being backed up, decides to grant, after the prosecution requested it, one more final conference before the April 29th trial. And this takes us to March 8th of 2024. Now, it was during this hearing where the court asked all parties, is there any preliminary matters to address before the court? Because trial is about 1 month away. That is the March 8th, 2024 transcript seen on page 8 of the record. And the prosecution responds, I don't believe so. I have nothing to address. So as to your point, Your Honor, yes, this is 4 years old. But even going from May 2nd of 2023, that second trial date, to the 4th, the prosecution had all of this time to prepare. And there's 2 more key points. One more is that in between the March 8th hearing and the April 29th hearing, we have 2 key things. So we go from March 8th to the April 24th, where the prosecution admits, hey, I have nothing to bring forth. But April 15th of 2024, 2 weeks before the trial, the prosecution files its witness list. And there it has Corporal Nichols endorsed as to come in. And so we get to this April 29th trial, and the prosecution's like, Your Honor, I'm not ready. Not only was one witness not prepared because he had scheduled surgery, even the prosecution admits in the record, April 29th transcript, that as the prosecution quotes, obviously it was a scheduled surgery. Well, if it was a scheduled surgery, how did you not come to find of it either within that 8-week time frame going from March 8th?
Mr. Rhodes, you don't contest that the corporal was a material witness, right?
Correct, Your Honor.
So this is just a question of whether there were diligent efforts made to get him there by the prosecution?
Yes, under
Okay.
MCR 2.503C2.
And you think there was not?
Correct.
Okay, say more about why there weren't diligent efforts made. And it sounds like they told the court as soon as they found out about his surgery. Is that not diligent enough?
No, Your Honor.
Okay.
Under MCR 2.5032, you have to have an unavailable witness that is material, and, as in the court rule, diligent efforts have to have been made to produce this witness. And in this particular case, when looking at diligence, as this court said in People versus George, that is 130 Mitch App 174, 1983, diligence is the attempt to do everything reasonable. So the question is, what was done reasonably? It's a scheduled surgery. You have 7 weeks to figure that out. And it appears that the prosecution in this case has a pattern of only contacting their witnesses the day before trial to finding things out. This is evidenced in the May 2nd, 2023 trial, when in that case, when the forensic scientist was retired, mind you, we don't even know how long he was retired, and the prosecution found out that he was out turkey hunting. Well, how long was he out turkey hunting? The prosecution wouldn't know, and this goes to diligence, Your Honor, because the day before, on May 1st, which was a Monday, before that second trial date, prosecution made contact with all their witnesses and found this out.
Mr. Rhodes, was there any prejudice to your client because of all these adjournments? I mean, I know the passage of time makes it more difficult to have these things hanging over your head, but beyond that, was there any prejudice? Lost witnesses, lost evidence, anything like that?
In that regard, Your Honor, no. And while it was true that Mr. Evans was not incarcerated or out, but 4 years, even post-COVID, 4 years of just having to go back to court, having to go back to court, having to go back to court, And although no material evidence was lost or any witnesses were gone,
It's a drug and gun case, so they
Yes.
presumably still had the evidence. It's not an ID case.
correct, Your Honor. And so as to diligence under the court rule, given the facts of this case, there's no way that the prosecution was diligent enough to be able to find that out. And I would like to bring this court's attention to that third trial date. We've been focused on the one witness that was out because of the scheduled surgery.
Let me ask a follow-up question to Judge Yates' question, which is, to what extent, if at all, do we contemplate the prejudice that he just asked about? So under this analysis, do we have to consider if your client's prejudiced at all, or do we not?
We do not, Your Honor. Under the court rule, I don't recall anything that would say if it's prejudiced, or at least according to some case law, if it was the defendant who moved for an adjournment and it wasn't granted, then there's a different framework in that situation where the court would have to look at to determine if there was prejudice in that case. And when we look at cases such as like People versus Coy, 258 Mitch App 1, that was a situation where 2003, that was a situation where the defense moved for an adjournment and it wasn't granted. And it appears that there are 4 factors that the court would consider in that regard. And that is whether or not the defense asserted a constitutional right, the reason for asserting that right, if the defense was negligent, and if there was any sort of requested previous adjournments or prejudice.
Has your client been recharged? Because it was dismissal without prejudice.
As of now, Your Honor, no, because it was without prejudice.
Is there a statute of limitations problem or something? I'm a little confused about why they chose to appeal instead of just charging again. It seems like an odd way to go.
That was my question. Thank you.
Sorry.
The prosecution's not here, and that's to the point, we don't know, Your Honor. The trial court did say in that April 29th transcript that, one, there's nothing spontaneous about the trial court that was set, years in advance. And two, the trial court even said to the prosecution, although this is not going to be like a quick expedited process, but yes, the prosecution could easily just refile the charges and start over again.
Sure.
So why are we here?
I mean, it's not your fault, but
Yeah.
If only the prosecution was here, but, and it just goes to the point of diligence. I mean, this is 4 years. The prosecution has had 3 bites at the apple, was unprepared. And to go back to the April 29th, 3 witnesses were unavailable, as the prosecution admits in the transcript. One of them had scheduled surgery, and the other 2 witnesses just had scheduled time off. And again, how does the prosecution not know that their witnesses had scheduled time off? And we don't even know how long that they had scheduled time off. We'll never know the answers to any of these questions because under the court rule, the prosecution was not diligent enough. And Your Honors, the diligent standard exists so that courts can effectively and efficiently run our judicial system and their own dockets. The prosecution's lack of communication and repeated last-minute disclosures forced the trial court to act to protect its docket, the defendant's rights, and the integrity of, its dockets. And to reverse would signal that unpreparedness may override judicial efficiency and strip the courts of discretionary authority that MCR 2.503 entrusts to them. Because the trial court reasonably acted well within its discretion and dismissed the case without prejudice, this court should affirm.
thank you very much, Mr. Rhodes. You did a really nice job.
Thank you.
Thank you.
You may. Thank you, Mr. Hall. You need to be at the lectern, otherwise we won't pick you up. But go ahead. Thank you, Mr. Hall.
This is nothing that Mr. Rhodes missed. He's arguing the case that we worked up last semester. But on the question of prejudice to Mr. Evans, I think it's fair to say we're not aware of any prejudice. I think to concede that there was none would be going too far. We made several attempts to contact and communicate with his trial attorney, and we're not able to. So we're operating on the record solely. Thank you.
Okay, thank you, Mr. Hall. That case will be submitted. Thank you very much. Let's move on to case number 3. This is docket number 369505, the People versus Kenneth Roy Gay. And I think we have somebody endorsed on each side of this case. So come on up, counsel, and whenever you're ready, Mr. Ferone, I think you're leading us off today.
Thank you. Good morning, Your Honors. Michael Frone on behalf of Mr. Gay. This case presents really a narrow question. Is it appropriate to score OV-19 for a suicide attempt? And first thing I would want to point out is that the prosecution's never argued or implied, trial court didn't find. In fact, I don't think there's anything in the record that would indicate that this wasn't a sincere attempt at
Sure.
suicide. I
Well,
mean,
let me ask you this, Mr. Frone, because this is what puzzles me about this case. Your client was out on bond when this happened, right? Now, if he'd been in a jail cell, that'd be a different thing, but he was out on bond, so he was making his own decisions. And he did not show up for the sentencing hearing, correct? Now, I know why, but he didn't show up for the sentencing hearing, right? And I think you would concede that if you simply don't show up for your sentencing hearing, you get scored for OV-19. Now, there are extenuating circumstances in this case, but can you at least agree with me that if somebody just simply blows off their sentencing hearing, they can be scored for OV-19?
if they simply blew it off, but not if they simply didn't show up. I mean, for example, if he was in a hospital. He was still-
Absolutely.
Sure.
Right,
Um,
but that's the problem, and you're going exactly where I wanted to go to. So if the facts are fully developed in this case, I think your position is going to be, there were extenuating circumstances. He did legitimately try to kill himself, and that's what happened. So we can talk about that issue, but just as a threshold matter, unless the record's better developed in other cases, you ordinarily would score OV-19 if somebody doesn't show up, right?
If it was done with an obstructive intent, because it's required.
Where's the intent requirement in the statute? That's what I'm missing.
Yeah,
It doesn't
it's-
say that. It says if there was an effect, right?
Well, I would argue interference, it's a verb, it requires an intent. And the case law all involve people that act with an intent. They tell somebody, don't talk with the police. They deliberately don't show up. The Cunningham case that the prosecution relies upon, he deliberately left the courthouse believing that's going to prevent the jury from delivering their verdict. If he just wandered off in Cunningham, and he came back and he said truthfully, well, my attorney told me I had an hour. I didn't know I only had 5 minutes. That's not scorable under OV-19. Why? Because there's no obstructive intent. You need to have an intent to interfere. You can't score it for a mistake. You can't score it for a misunderstanding. It's an intent. And all the case law implies there's got to be an intent. Here, there's no evidence of it that he attempted suicide intending to show the court. If there was a note.
Yeah, move on to your, what I think is the strongest argument you want to make, that the trial judge appeared to rely on the suicide itself as the reason to score OV-19, not the failure to show up at sentencing.
Oh, correct.
That's how I read the transcript.
Correct.
So then we get to the question of whether attempting suicide is scorable, right?
Well, correct. I mean, I don't think there was no finding. Well, I don't think the facts are even in dispute. As to what happened, I may not be fully understanding where the court's going.
Here's the thing. I mean, if we're going to rule in your favor, the most dangerous thing we could do is write a really expansive opinion that says, okay, you don't score OV-19 even though he didn't show up at sentencing.
No.
Which is, I think,
Sure.
incorrect as a matter of law.
No, I agree.
But I think what you're saying is the trial judge didn't penalize him under OV-19 for not showing up for sentencing. The trial judge expressly punished him under OV-19 for trying to kill himself.
Correct. Correct. I mean, that's the only reason he didn't show up. I mean, the day after he's in custody, he was out on bond. The day after his suicide attempt, he's in the police custody. I would argue that what went wrong here is the trial judge punished him for the suicide attempt. That was the only basis offered for the scoring of OV-19 was the suicide attempt.
Not the failure to show up for sentencing.
Well, correct, because the failure to show up isn't scorable in and of itself. When that's scored for failure to show up, when it's scored, it's the court will make a finding. You flaunted the authority of the court by not showing up. Otherwise, right, we don't score it. If he had injured himself and gone to the hospital, nobody would think about scoring OV-19. If he had came in, I see this all the time, and said, well,
I want to unpack that a little more. So failure to show up isn't scorable on its own, even though a failure to show up could, by definition, interfere with the administration of justice.
well,
So if the effect of your actions is not showing up, which interferes with the administration of justice, that may still not be enough to score OV-19. even if that's the effect of your actions? How come?
Well, it has to be willful. I've been to court, we all have many times where the defendant will come in and say, I apologize, I didn't show up. It's my mistake. I had the wrong date. Nobody gets scored OV-19 under those circumstances if the court believes the defendant's telling the truth, because there's no willfulness. There's not an intent to obstruct with justice. All these cases that we look at under OV-19, they use the language of the obstruction statute. They use the word obstruction. It requires an intent.
But there's published case law that says it doesn't need to be an obstruction of justice.
But obstruct, those are the words that are used. Obstruct or similes of obstruction are used throughout the case law, I believe.
Oppose so as to hamper, hinder, or obstruct, I think is the
Right.
language.
Right.
So the statute itself, if you look at the language of the statute, talks about interfere with or attempt to interfere with. In my mind, that suggests the intent component is in the attempt, and that you can interfere without an attempt, but if you're attempting to interfere, there's an intent. Right? So I don't think the case law is that clear that there's an intent requirement every time you score OV-19.
I would disagree. I think there is. I don't think the intent is behind the act itself. Like he intended suicide. All right, granted. No, it has to be an intent to interfere. The variable is scored for opposing, hampering, obstructing. That's where the intent comes in, not and maybe it comes, probably both. It comes in with the act itself. I don't think you can separate them out. So there has to be, otherwise, no, I am asking, to get back to your question, Your Honor, Judge Yates, I am asking for a fairly narrow ruling. I'm not asking for a holding that
Right, I
somebody,
was hoping you weren't
just
gonna
because somebody,
ask us to write something so
No.
broad that we essentially throw out the well-understood and completely appropriate scoring of OV-19 when somebody just simply blows off their sentencing.
well, right. And for example, in this case, if it's a sincere suicide attempt, however, if there was, for example, a note where he said, I'm going to show the court, they're not going to have a chance to sentence me. I'm going to kill myself. And then he survives. There's an intent there. There's an intent to frustrate justice, but it's missing here. All we have here is, I killed myself because I wanted my son that's going to help him get his child back. And okay, but there's nothing that you can believe it or not believe that's the reason, but there's nothing that pushes back on that. There's nothing that indicates that wasn't why he attempted to kill himself. There's got to be something more. So yeah, I'm not actually.
You think courts should have different outcomes based on your motivating reason for attempting suicide?
Well, no, I think that would be a gray area. I'm not saying necessarily it would be scorable in that incident, but at least if there's a note there saying, this is why I'm doing it, to frustrate the justice, to frustrate the sentencing. I mean, at least that's a different case. That's not this case. And at least there would be an argument, but we don't even have that in this case. All we have is, I'm going to score OV-19 because you attempted suicide and didn't show up. I mean, that is punishing someone for something that doesn't involve any sort of even minimal effort to interfere with the process. If there was something to show that was his motive, then we would have a different case, but we don't have that. It's just, he attempted suicide. He went to the hospital. He's in custody the next day. He's sentenced 2 weeks later. Now, there's nothing that indicates that his motive, reason, intent, purpose in attempting suicide was to frustrate the process. And yeah, I do think that's required under OV-19 because these are aggravated sentencing variables. These are variables where we increase the punishment or potential punishment because of something the defendant did. By their nature, they are things that the defendant did to aggravate, to make worse the situation. Yes, and we also, part of the problem with scoring OV-19 under these circumstances is we are punishing somebody for being or having a mental health issue. I know the prosecution disagrees with that. They say it was a rational decision. Maybe my brief is inadequate. I admit I'm using the word mental illness broadly. I think most people do. I guess if I could do it over, I would have said mental illness or mental disturbance or something. We're not arguing he wasn't competent, couldn't make a rational decision. That's a much higher standard, not our, legal insanity, much higher standard. All I've argued is he had a mental health episode. I would argue people who attempt suicide have some type of mental health issue going on, defined broadly, depression. I was just trying to think of an example. Where might somebody attempt suicide, but it's just a purely rational decision and there's not a mental health issue? Because they really do push back on that strongly, and I can't think of any. I know in Canada, I don't want to get into that, but I know they have assisted suicide. I think most of those people are depressed. So I think you can't separate suicide attempts from mental health. So disagree with them on
Let me
that.
go back to Judge
Sure.
Boonstra's question. Okay, so the relevant statutory language is the offender otherwise interfered with or attempted to interfere with the administration of justice. So the sentencing was delayed. And is that, so let's ignore the underlying fact for a second. This is a no-show in sentencing, delay in sentencing, and interference with the administration of justice under the statute.
Well, but maybe that relates to what we argued in the brief, that this is a de minimis interference with, I'm using the word interference with justice. I mean, he was sentenced 2 weeks later. This isn't a scenario where somebody flees the jurisdiction and the police have to go out and find him and spend resources locating him. So I do think it's important that and we talk about that in the brief with, I think it's People v. Sowers, that they don't say it. I think they kind of indicate, look, people do things which hinder the process, but in that case, I think it was the defendant had a probation violation or parole violation, didn't report or something to that effect. Yeah, if you look at it in a certain light, it's a hindering justice in that case, but it was so minimal.
To your earlier point, in terms of intent, which I think we all agree is not expressly spelled out in the statute, we have to read it into the word interference. Whereas Judge Brunstra talked about if intent is read, it could be read into attempt. But we would have to read it into interference for this not to be scored under OV-19.
But I think the intent is an intent to hamper, obstruct, interfere with the process, not the act itself. I could think of examples. The person, I feel like I'm sick, I'm going to intentionally go to the hospital. The hospital convinces him you can't leave, so he misses his sentencing date. The intent is to go to the hospital, but you're not going to score, no court would score OV-19, I don't believe, because he's following his doctor's advice, he's staying in the hospital. So yes, the intent to interfere, that's read into the word interference and not in the underlying act. So the intent here is to interfere with the process. I think that's what our case law states, that it has to be a volitional obstructive act of some kind, maybe, or hampering, an intent to hamper. I keep using the word obstruct. I understand there's different words. They're all verbs and they all require a purposeful intent behind them.
If we look at all the examples of things that are scored 10 points for OV-19, suicide attempt is categorically different. Agreed. Right. However, the difficulty is that's sort of like the reverse of generally understood statutory interpretation, right? Like I'm not going to jump to the case law first and then loop back and then use that to interpret the statute. I'm going to look at the statutory language first. And so that's kind of why I keep going back to that, is because there is not an express intent requirement.
Well, true, but there's not an express intent requirement, I don't think, in any of the offense variables. I mean, but it's not stated, the word isn't spelled out in the statute, but it on the other hand, it is. I mean, if the words interference, obstruct, hamper, but if we look at all of the offense variables, it doesn't say that, for example, the defendant has to have intended to put, I mean, that'd be the best example because that kind of goes back. Let me think of a different one. I was about to refer to the number of victims. The defendant has to intend his act. Let's use a different one, OV8. I mean, or brutality or whatever. There's nothing in the language that says the intendant had to intend to brutalize the victim, but we're not going to score the variable unless unless the attendant's actions were intended. So I think that's true of all the offense variables, that maybe they don't use the word, spell the word out in the way I am, I
Well,
guess, but it's implied in all of them that.
Well, hold on, Mr. Front. What about, for example, moving a person to a place of greater danger? Do you have to actually, in your mind, think this is a place of greater danger?
Well, no. And I haven't gone through each variable. There may be some where my
Right.
argument doesn't hold up as well, but you do have to, intend to move the person.
Right.
I mean, actually, I would say to some degree, it does get applied there actually, because I actually argued this issue just 2 days ago and, there was I'll talk about a case that's in front of the court, but the victim said, well, he moved me from point A to point B for this reason, this innocent reason. And, it's kind of an interesting question because the prosecution got the variable scored arguing, no, it was, well, wait a minute, the record says the opposite. The record has said all these other things that didn't show up in sentencing. They showed up in police reports. There was no contest plea. So I would argue, no, actually, there's an intent behind all of these variables. And that's the nature of criminal law. We don't punish people, and the variables punish people. This case, because of the scoring, the range went up. He got a larger
20 months, right?
right, and
At the time.
that's the whole sweep of criminal law. Generally speaking, with very few exceptions, and I understand I'm talking, maybe apples and oranges, offense variables, guidelines, but I don't think so. The whole sweep of criminal laws, we punish people more severely.
Right.
That's the guidelines for.
Bad acts and
Isn't
guilty
that-
minds.
Isn't that Milborn? We punish people more severely for more serious offenses and background. So, no, I think if we're going to increase someone's sentencing under OV 19 for interfering with the administration of justice, there needs to be something in the record to show that was his purpose in the act, was to frustrate justice.
And with respect, just to get to the intent thing one more time, if we think about false name to the police, right?
Right.
It could be a situation where you're like, oh, I'm John Smith. And they're like, no, we know who you are. You're da-da-da. And it doesn't actually delay the processing at all. That individual could still be scored for OV-19 because they intended to, because they attempted to, albeit they were unsuccessful, but the intent there is with the disruption of the process. The intent is not with the attempt. Does that make sense? Like I'm trying to identify, so in that way, the case law could be helpful in the statutory interpretation because the actions that are scored may not actually interfere with, but you intended that they interfere with justice, with the fake name, with the fleeing from police, with the, that sort of thing. The intent lies with the interference and not with the
act itself.
Yeah.
Yes, I mean, all of the cases that I've seen involve people who intended to interfere with the administration of justice. The argument I make in the brief about this was just a de minimis interference. I'll concede they have a good point on that. There's no case law
Yeah.
that that's an argument I made. Maybe I shouldn't have, but to sort of put this in context, I'm not arguing that, that's not the greatest argument in the brief. I'm not arguing that a de minimis interference. I mean, they got a good point on
There's
that.
something to the fact that his hospitalization delayed sentencing by 24 hours to a week, and the attorney's vacation schedule delayed sentencing more than that. But that's more to your point. Is that is there something like legally significant to that. I'm not sure either. I don't know that there's a de minimis requirement. If you just delay a day, I'm not sure that that matters under the plain language either. But I do think that the facts here are interesting because of that, dynamic that played out in the delay of sentencing.
Right. Yeah, I'm not pushing the argument, but I agree. There has to be some type, and actually, if we look at, I mean, in my brief, I didn't really get indignant. I could have, said this is outrageous. I understand. I mean, I think I think she's a good.
You're
I think
always
she's-
measured,
I
Mr.
think
Corona.
she's,
We
I like,
appreciate that.
I like this judge, but I did want to point out, if we look at the reasons the judge gave for scoring OV
Mr.
19.
Corona, you're at 25 minutes
Oh,
now. You can keep going if
no,
you
no.
want, but I have a feeling you may have some things you want to
Well-
clean up when Ms. McLaren finishes.
Oh, thank you.
Okay, thank you very much. You have 5 more minutes if you want to use them, but it's up to you to save them. Okay, Ms. McLaren,
Good morning,
as you
Janet
can
McLaren.
tell, we're very interested in this
It is an
case.
interesting case. Janet McLaren on behalf of the people. Judge, I just want to make a few points. I know that you have all read my brief. I don't think that OV-19 does require any type of intent, and nor do the other OVs. For example, counsel gave the example of treating a victim with excessive brutality. If there was meant to be an intent there, then the legislature would have said, let's say that the defendant intended. Instead, it says the victim was treated
Right.
with excessive brutality. So I think that's important to know. Secondly, I know that Judge Yates, you talked about that the court seemed to focus on the suicide and not him not showing up.
Yeah, stop for just 1 second, because I think you can give me the answer to what in my mind is the most important question.
Okay.
Was the enhancement under OV-19 imposed, A, because he didn't show up for sentencing, B, because he tried to kill himself, C, both of those, or D, neither of those?
You've anticipated my argument. I think it's both. In fact, if you look at the sentencing transcript on pages 26 through 27, the court says, after going into that she believed he was engaging in self-righteous spew, but then
Right,
she says,
right.
you are a coward who couldn't face what you have done to this child, and that you couldn't face this court to be sentenced. So I think
So there are 2 clauses there, and you say clause 1, you tried to kill yourself, clause 2, you didn't show up for
yes,
sentencing.
I would argue that it is both. And I think the court's already focused on the other key issue is that OV-19 includes attempts. It could very well be, I cannot look into the mind of this defendant and say why he did this. I don't think we have a clear-cut record on that, but it could be both. He could have said, excuse me, Your Honor, it could be that he said, I don't want to burden my family anymore. And, also if I do this, I won't be showing up for sentencing. So as to the mental illness aspect of this, again, I'm not a psychologist or a psychiatrist. I have no idea about this, but I will add that I quoted on page 2 of my brief what the defendant says, and I think we have to take him at his word. He said, I'm not crazy. I try to think logically. I try to help myself and the people around me at any time that I can. And I just thought this has got to end. And then he goes into all the reasons why he chose to do this. So I don't believe that, the defendant says he didn't do it because of a mental health component. He said he made a logical decision. And we have to take him at his word because
Now
none
you're
of us,
sort of focused on his intent.
pardon me?
Now you're sort of focused on his intent. what
Well, I'm
was
just
in his
responding to
mind.
him saying that anyone who commits suicide can't be in the right frame of mind.
So let me ask you this. What if instead of trying to kill himself, he was in a car accident and he was taken to the hospital and he was there overnight and he missed his sentencing as a result?
Then I don't think we'd be here because that's out of his control. He didn't do anything to get into a car accident.
But where's the control element in the statute? It says it had the same effect.
You
It
still have,
delayed the sentencing.
but you have to do something, right? You have to do something. What he did was he attempted to commit suicide. If he's
Well,
just
he-
in a car accident, all he did was drive wherever he was driving. There was
What if
nothing
What
there.
if he thought, oh, I've been arrested, I gotta go to court tomorrow, I'm just beside myself, I'm driving a little recklessly and I get into an accident? That was kind of
Again, I think if you can prove that he did something, maybe cuts in front of a car,
So
maybe.
if he's the at-fault driver, then he can be scored. and if he's
Maybe,
not,
I mean, that's a different question, but here he did something and the court said that the reason he did it was to avoid coming to court and being sentenced.
That's Judge Brewster's exact point. You just said the reason he did it. So we're back to intent. So
Well-
either it sounds like we're reading intent into the statute or we're reading some sort of act requirement.
I
but-
see your point. I don't think intent is required, but I do think the judge did focus on the fact that he did not show up for sentencing. I think that is the act more than intent. That's the act that she was focusing on, is that he did not show up for court because of what he did. So I see that there's a fine distinction and I see the fine line here. I do.
this is a very hard opinion to
So
write.
if not,
I can only imagine. I'm glad I don't have to do it.
if the key factor is not showing up for court because of what he did, then the car accident gets scored too.
Maybe it does, depending on the circumstances. That's the judge's determination, right? And here the judge was in the best position to make the determination that she did, which is that she indicated that he didn't show up because he couldn't face the court. And that was OV-19, which indicates that it is scored for being caught and held accountable for the sentencing offense.
Yeah, it sounds like the judge, in a somewhat inartful way, made a finding of fact that the reason for the attempted suicide was not the custody matter. I mean, the sentence before the one that you were focusing on says, it just seems like the selfish, self-righteous spew that you still see yourself as the victim and, oh, I should have killed myself so my son could get custody. That's why I was doing it. If I read the right sarcasm into it, it sounds to me like the court's making a fact finding that that was not the reason he did it. The reason he tried to kill himself was so he wouldn't have to show up for sentencing.
I don't think that that's what she was doing. I think
Okay. All right.
again, I think, okay.
I would, okay, so that issue's still in play then, about what the reason was that he even tried to kill himself.
Well, I think the last sentence of that is the telling one where she says, you're a coward who couldn't face what you've done to this child and you couldn't face this court to be sentenced.
Anything else, anyone?
issue.
Yeah.
It is.
Thank you. This seems like a law school exam question. Okay, Ms. Fro, you have 5 minutes. Give us your
I
best
probably won't
pitch.
take up 5 minutes. I would state that if, I'm not asking the court to read intent into the statute. I think it's already there in the words hamper, obstruct, oppose. And I believe that if the court reads I think we all agree, I think we agree there's an intent that's required. It's whether it's the underlying act, intent to commit suicide, or whether it's intent to hamper, obstruct, oppose. If you read it into
Specific intent versus general intent for all practical purposes.
I think if you read it into, or read those words as requiring an intent to hamper, obstruct, and oppose, you'll eliminate a lot of problems in the future. A lot of the law school questions will go away. I mean, what if you went mountain climbing the day before and broke his leg? The judge could say, well, that was reckless. You know, now the sentencing got delayed for a month. Well, he didn't intend to, but he intended to go mountain climbing. You can eliminate all of these problems, all these law school questions, and it'll be a lot simpler to apply the variable in the future if we say, as I think all the case law does already, the defendant has to have intended to hamper, obstruct, oppose. So, all right, thank you.
Thank you, Mr. Barone. Thank you, Ms. McLaren. That is truly a fascinating case. It is submitted. Moving on to case number 4. This is docket number 366733, the People versus Elliott Kwame Ingram. Remarkably, each side has waived oral argument, and so that matter will simply be submitted on the briefs. Let me clear this file out of the way, and we'll move on to number 5. Case number 5, docket number 372930, is the People versus Michael Daniel Baird. And I believe we have someone endorsed on each side of this case. So please come on up, make yourselves comfortable, and we'll be glad to hear from you. All right. For the appellant.
Yes,
Come on up.
good morning, Your Honor. May it please the court, Tyler Beadle, P7570.
Yeah, we're not picking you up yet because there's no mic over there. I'm sorry about
Yes.
that. The only place you're heard on this side of It's, if you're standing at the lectern. Okay, go ahead, start again.
Thank you,
please.
Your Honor, and good morning, Your Honors. May it please the court. Yes, so this case, I'm sure as you've read in the briefs, this case turns on two simple but critical propositions. First, when a person is convicted based on a BAC reading that sits at the legal threshold, the Constitution requires the state to present every witness whose testimonial work contributed to that result. Second.
Well, wait a minute, that sounds like a raised gesti rule. I mean, isn't the person who actually ran the test enough to come in, offer the expert testimony, and then if the report comes in and that person authored the report, that's good enough? It can't be the case like the old raised gesti rule where everybody involved in the process has to come in and testify.
Well, certainly, Your Honor. And so this lab tech performed scientific work on the blood samples. And so this is not just a chain of custody or a labeling or putting the samples in the correct spot. This is actual work on the blood that could potentially cause a variance in the reading. And so this is a case where the blood was at 0.089 with a margin of error of 0.009. That puts it at exactly 0.008. This is a blood test. This is a 0.00 or a 0.08 test. This isn't a bad driving test. This isn't substantially affected his ability to drive. So the prosecution is relying almost solely based on the test. Now, there was some driving that was out.
Okay, but doesn't the statute say reached or exceeded 0.08?
Yes.
So what, so let's say, even if we were to agree with you, why does it matter?
Yeah, so that's exactly right. So, so 0.08 is the legal threshold. So based on their own level of what it could be, so 0.089 with a 0.009 level of uncertainty, it could be down to up to a 0.096 or down to a 0.08. That means that if there is anything that is outside of what should normally be done with the blood that could affect the test, even 1/1,000,000th of a percent lower would be under the limit. And so he would be legally driving. This individual is allowed to do all things that are legal, and we encourage him to operate within the law. If he's a 0.07999999, we say, go have at it.
So the person who did the testing did testify.
Correct.
And they said upon obtaining the sample that they tested, did they indicate that there was any irregularities with the sample that they obtained to test?
No, they did not.
And so this is hypothetical that you would call the person who processed the initial or put a label on the bottle, and they would say that they dropped it or touched it themselves, or this is just.
Correct.
Because
So
there's a world in which they say, yep, no, I had gloves on, I stuck the label on, and I set it in a mailbox and was done.
yeah, I mean, if they came in and testified and said that everything was done correctly and within the procedures, but the person that they sent there does not know that. They do not know whether it was done within the procedures, and this is exactly what the case
I mean,
of.
in terms of us finding error, it's difficult where it's completely hypothetical. Like there's a world in which this person testifies that everything went according to plan.
Well, yeah, it's a confrontation clause. It doesn't matter if everything went according to plan. It matters that my client had the right to cross-examine that person and find out if that's the truth.
Well, I'm glad you brought up the confrontation clause because now I'm really confused. Because with regard to the confrontation clause, you certainly can't make the argument that the person who did the testing and came in and testified, that person testifying about the result violates the confrontation clause. The person's on the stand testifying, they can be cross-examined.
Certainly, Your Honor.
So it seems to me the only thing you're complaining about is the report coming in, right? Because if the expert had taken the stand and testified, I ran tests, my results were 0.08, whatever.
Right.
There's no constitutional violation at all when that happens, right?
Not if that person, not if there was a proper chain of custody, that person.
No, that has nothing to do with the confrontation clause. That person comes in, says, I ran the test. This is my test result. This is what the BAC was.
If that.
It can't be a confrontation clause if somebody else didn't come in. It only becomes a confrontation clause problem, I think, if the report comes in.
Right. Well, yes, the report came in, but
Okay,
yes.
but why doesn't the testimony of the expert standing alone easily justify the jury's verdict, and the report coming in is at worst harmless error?
Because that
It's
person is,
cumulative.
that person is testifying as to work done on the blood by somebody else. And this is exactly what was was designed to be prevented by Bull Cumming v. New Mexico and also Smith v. Arizona. That in those cases, a separate analyst came in who hadn't tested the blood, right? And they testified that, yes, this analyst, I know this analyst, they work in my lab, they do this all the time. We both do the same type of work. And so their work is exactly like mine. This was the report that came out with the work done. That was exactly how I would do it. And so I'm testifying that this is an accurate report.
But where's the out-of-court statement that's testimonial and the expert just coming in and saying, I ran the test, these are my test results? The only out-of-court statement coming in is from the witness who takes the stand and is subject to cross-examination. Thereby, there can't be a confrontation clause problem.
Well, so the analyst is saying that she relied on the work of the lab tech to even get those samples prepared. And so her work was, she didn't complete the entire analysis of the blood. The first steps were taken by the lab tech. And so exactly like not having the analyst there who did the work, we don't have the lab tech there who did the work on the blood to get it ready.
What do you mean by did the work on the blood? My understanding is that this person cataloged the blood samples when they were received and then checked to make sure the vials weren't broken. Are you suggesting she did more than that?
I am. So the analyst said that they also prepared the samples. Now, so yes.
What does that mean? Prepared the sample?
Yep. Yes, Your Honor. So, my understanding is that they would have had to transfer the blood into headspace vials, add the internal standard solution, seal those vials, and arrange them into the batch and document any abnormalities. Now, this is not simply like I'm saying, chain of custody, but I know the court is taking some offense to that term, but maybe more appropriately, not chain of custody, but actually putting things into the blood or setting the blood up and so that it can be analyzed. It's for, I'm sure it's for efficiency, but if they made an error, like I said, if this is 1/1,000,000th, 1/infinitieth of a % lower, my client's under the limit in driving legally. And so every single thing matters. And so that's what I would say to that. So yeah, I mean, when the outcome hinges on 9/9,000th of a gram, and then outside of that 1 more millionth of a gram lower, every contributor to the scientific process matters. And when one of those contributors does not appear, confrontation is violated. So on to the second issue, the jury instruction issue. The jury never received guidance on how to evaluate preservation deviations or the evidence showing the sample was not cooled in transport, which the analyst testified that that's what the manufacturer recommends, is that this is cooled in transport. The standard jury instructions allow the juror to infer stability. There's an inference, but it does not inform them that they may consider instability or uncertainty, which is at the heart of our defense. A scientific result that may equal the legal limit cannot be left to inference alone.
But the prosecution's burden is to show that there is a BAC of 0.08 or greater, right?
Correct.
All the things that you're arguing go to challenging the reliability of the number provided by the expert witness who testified, right?
That's correct, Your Honor.
So if you want to cross-examine on all that, that's fine, but it doesn't add an element to the offense.
No.
The prosecution doesn't have to prove that there was no mishandling of the blood in some way.
No, certainly not, Your Honor. But when there's been a showing that there's been a mishandling of the blood, I believe that a jury instruction should be given on that. But more than that,
To say what?
well, to say that they may take that into account, and because the issue here, if this was just a fair trial, in my opinion, right, then we wouldn't have to worry about it. But there's a standard in jury instruction that the prosecutor is allowed to use, and that's that the jury may infer that whatever the blood was at the time of that it was taken, which could be hours later, was the same at the time of driving. And so to give them that instruction, that's simply not true. So you're telling the jury to infer something that's not true. No one believes that that's true. No one believes that the person's blood at the time of driving is the same as it was at the time that the blood was taken, when it's several hours later. The only way that could happen is if the blood was rising at the time of the pullover and then decreasing, and it just happened to be at the same point. And so the jury, when you tell them that they can just infer that number is true, basically, that's just simply not fair to my client, and especially with some of these discrepancies and the fact that based on the range that he was at 0.08, the very minimum, they need to know that, hey, you can infer, but that doesn't make sense. That's not fair to my client to just infer that that's correct. There needs to be some other instruction.
The legislature gets to make some of these decisions. I mean, the legislature used to say that drunk driving was 0.10,
Right.
and it said it's 0.08. I mean, is that a violation of due process when they drop the blood alcohol content number? I mean, I don't understand. I don't understand what the stopping point is of this analysis you're providing.
Oh, the stopping point of the analysis as far as,
Look, when the legislature steps in and allows for presumptions, for example.
Right.
I mean, you seem to be arguing that any presumption's unconstitutional in some way.
This particular presumption is particularly unfair when we know that that's factually inaccurate to do that, and we're telling a jury to follow a factually inaccurate analysis. That's my strong opinion. I believe that, and so some type of instruction needs to be given to the juror to say, yes, you can do this, but there are some other issues that you should consider as well. Thank you, Your Honor.
Thank you.
I have one last question.
Oh,
Yes.
sorry, I'm
So
sorry.
No.
Sorry.
Your confrontation clause argument is based on the fact that the lab tech didn't testify. Am I
Correct.
right? What about the phlebotomist? Don't we need the phlebotomist too? She drew the blood
there-
and she sent it on through the chain. Why don't we need her too?
She did testify.
Oh, she did.
Yeah,
Okay,
but
that's fine.
but as far as yeah, I mean, she should have to testify. I mean, if she did some scientific work on the blood, I believe anyone who did work on the blood, this isn't like a gun where it's like it's the same gun that gets moved over and over. This is something that is a compound that can change based on heat, based on lights, based on anything.
Anybody who touched it in the custody through the chain of
So
process.
I'm not arguing that. Anyone who did work on the blood, so actual work on the blood. So my argument is that they put the blood into the vials, put the solution in, made it ready for testing. Thank you. Your
Thank you.
Honor.
You'll have some time for rebuttal.
Thank you, Your Honor.
Morning.
Morning, Your Honors. Nick Johnson, Assistant Attorney General, on behalf of the people. May it please the court. I know the court is very familiar with the Confrontation Clause case law, particularly the recent decisions in the last decade plus from the United States Supreme Court. This is not a surrogate testimony issue like in Bull Cumming. We have here the report at issue was a certificate from Crawford and Melendez-Diaz. The court says that is a testimonial statement. Defendant is entitled to cross-examine that. And both Melendez-Diaz and Bull Cumming specifically say that the author of the report has to be there to testify. And that's what we have here. As far as opposing.
Let me just make sure I understand this, because it sounds to me like the report was marked as an exhibit, admitted, and taken back to the jury.
That's how I understand it, correct.
So if that report had not been offered in evidence, there wouldn't be a confrontation clause problem if the person who did the test showed up, testified, explained it, and said, I've got a BAC of whatever level. And then the jury convicted on the basis of the testimony, not augmented by the report.
I think that's fair. Absolutely. I think with the report itself falls within that class of category of testimonial statements. So once that's admitted, defendant has a right to cross-examine that, and that being the author. But yeah, I don't believe there'd be a confrontation clause issue if that report was never admitted.
Yeah,
I think it just enhances
California
credibility.
versus Green, right? I mean, it's
Yeah,
a
it just enhances the
straightforward-
credibility of the witness, and they explain there, and it's common practice. So I want to get to the point about the lab tech's work on the case. As I understand the record, all they did, as Judge Boonser indicated, was simply document that it was received. They didn't do any testing. As I understand it, Faust, who was the lab technician or the lab analyst who did the work, she explicitly said that the seal wasn't broken. So I'm not aware of anything that had been done to the blood. As I understand the process and the record, essentially that lab tech who did not testify didn't do any work on this.
At most, she was just one
Just
more
simply
person in the
documented.
chain of
Absolutely.
custody.
Absolutely. And Melendez-Diaz explicitly rejects the argument that anyone whose testimony may be relevant to establishing the chain of custody, or even those who handle it, must be called to testify. They said that's simply a chain of custody issue, that it goes to weight, not the gaps in the chain go to weight, not admissibility, and the trial court here explicitly recognized that as well. So if the court has any more questions on that, I'd be happy to try to answer them. I think that my brief pretty adequately addresses it, so.
Everybody okay in there?
Yeah,
Okay.
and then with respect to the second issue on the jury instruction, I think I think the standard instruction captured exactly what the jury was supposed to consider, and that it allowed the jury but did not require the jury to infer that his BAC at the time of operation, I'm sorry, the time of testing was the same at the time of operation, and the jury was free to give whatever results deemed necessary. So if the court has any questions on that or the case as a whole, I'm happy to answer it. Otherwise, I'll rest on my brief.
Thank you very much.
Thank you.
All right, Mr. Villo, you have 5 more minutes if you want.
Your Honor, I'll waive my additional, any remaining time unless the court has any questions for me.
No, I think we're all set.
I'm
Okay,
all set.
everybody
Thank
okay?
you.
Thank you, Your Honor.
Thank you very much. That case will be submitted. Moving on now to case number 6, docket number 368164, the People versus Furquan Knox. Mr. Schrotenboer, I see you approaching. And Ms. Sharon? Good morning.
I'm just gonna lower the.
That's fine.
At least you know how to do it.
You know what? Last month I was in Detroit and the podium seemed, or Grand Rapids, I can't remember, and the podium was so high and you can't adjust it there. And I just felt really out of place. Thank you for that. Good morning, Your Honors. May it please this honorable court. Alona Sharon on behalf of the defendant appellant, Mr. Knox. I know Your Honors are very familiar with the issues and the facts. I just want to touch on 1 or 2 of what I think are the strongest points in the brief. And of course, if the court has any questions, I will do my best to answer them. I think that there is a significant concern in this case regarding Judge Aquilina's piercing of the judicial veil. Judge Yates is nodding. I don't want to get to.
It's a very high hurt. I mean, I recognize that it probably would have been better had that not been said, but it's a really high hurdle.
And I think it is a hurdle that Mr. Knox meets, Your Honor. I think you have a trial here that consists of, I think it's 9 witnesses, but we have essentially 11 occasions when witnesses are excused from the witness stand. And for every witness, Judge Aquilina makes the same comment, right? Don't discuss your testimony with anybody else. But for the 2 complainants in a CSC case, she adds the comment, but if you're in therapy, you should feel free to talk to your therapist. And I think that this is very similar. It's not exactly, but extremely similar, and similar enough to the Hudson case that I cite, where this court found that the impartiality was pierced. I believe it is the same here. You know, you can't have witness after witness after witness where the judge is making a statement, but then for the complainants, it's something different. And that statement very much endorses their allegations of being victims of sexual abuse. I think that the error is structural. I think anytime.
Remind me, did the victims testify to being in therapy?
I believe that, and I think actually opposing counsel talked about them talking about being traumatized and upset. One of the mothers talked about one of the girls cutting her arms, finding her bloodied in bed. So I don't remember specifically if there was conversation about them being in therapy, but certainly about having been traumatized and suffering significantly from a mental health standard during trial. Absolutely. There was.
I was more wondering if they were like, and also, and now I'm in therapy. And then she was like, okay, you know, sort of if it was like responsive to their testimony.
Sure.
And how, and if that would make it different.
Your Honor, candidly, I would have to double check the record. I'm happy to do that and follow up with the court.
Well, let's say they did. Does it make a difference?
So I think either way, this is reversible error, but I think certainly if there was a fact pattern like Your Honor is suggesting.
And I don't know that there is. I'm just saying, let's say.
I think even more so, it would be vouching and piercing of impartiality. Because then it's like, well, we already know you're in therapy. I just think it almost sort of encourages it. But actually, now that I say it out loud, maybe not having mentioned that they're in therapy actually makes it worse because
That's-
there's sort of an assumption on the part of the judge.
Yeah.
You're a victim. There's a likelihood you're in therapy. And, sometimes you have to talk it out and
No, that's, and
get
that's
yourself
like what
there.
I'm doing with you right now.
Yeah.
So yeah.
Yes, I think actually that is more prejudicial if there is no testimony about there being in therapy. When Your Honor asked the question, I know opposing counsel was shaking his head. So I trust opposing counsel but there was testimony about her suffering from a mental health perspective, but I can't say with 100% certainty whether or not there was testimony that she was in therapy.
Ms. Rowe, I appreciate your reliance on Hudson, but can we talk about Hudson for just a moment?
Of course.
Because first of all, it's an unpublished case, and I recognize it's not binding, but it's worth something. My bigger concern, though, is the remarks in Hudson were truly extraordinary. That's the case out of Kent County, right?
Yes.
And
Your former stomping grounds, I think. I had a case in front of
Right.
you when you were in Kent County, because you weren't there for particularly long, were you?
I was there a long time, but
Were
my
you?
last 10 years were on the business court.
Okay, well,
So
that's
unless
why
you were
I-
doing commercial litigation, you
No.
wouldn't have seen me for my last 10 years there.
No.
So, but the thing about Hudson is those remarks were, without offending one of my former colleagues, those remarks were completely over the top. I mean, the judge wasn't just talking about the witnesses perhaps being in therapy. The judge was essentially offering therapeutic services to the jurors because surely they were as traumatized as he was. And my gosh, was he traumatized.
So I'm actually going to respectfully disagree with you, Judge Yates, and this is why. Because in Hudson, the judge doesn't reference the witnesses, the complainants needing therapy, right? The reference is to jurors having heard very disturbing testimony.
Right, the jurors needing
Right,
therapy.
but the testimony is disturbing whether or not it's true or not, right? When you sit in a case as a juror, I've never had the pleasure, I'm sure none of us have.
I did this summer.
Oh, really?
I was the fourth person on a district court jury.
Oh, that's hysterical. You hear testimony that is going to be upsetting, whether it's true or not, right? It's upsetting if someone is making a false allegation. It's upsetting if it's true. But when you're saying to the actual complainant, if you're in therapy, you can discuss your testimony, that is an endorsement of the veracity of the complainant. So I would respectfully disagree. And I think actually this case is more harmful. And I would remind the court that in Hudson, there was even a corrective instruction the following day.
Yes.
And we don't even have that here. Instead, we have Judge Aquilina months later saying, yeah, I said it. That's okay. Okay. Moving on. I do just want to briefly touch on the issue of resentencing. I think number one, it absolutely needs to be remanded for resentencing because I don't think, right, when a judge imposes a discretionary consecutive sentence, there has to be a sufficient explanation as to why the discretionary consecutive sentence is done. I think that was insufficient here.
So so that's true under Northfleet, but didn't the judge basically say this is all part of the same transaction?
That's what gives her legal authority to impose it. But whether or not it's appropriate, right? The first step is, do I have legal authority? Does the judge have legal authority to impose it? The second step is explaining why it's an appropriate sentence. And under Northfleet, you are correct, Your Honor, and that is missing in this case.
Let's go back to the same transaction. Do you take any issue? I didn't read your argument as taking issue with the first part.
I believe that discretionary sentences are authorized. I don't.
So you don't take issue with the same transaction finding?
I take issue with it from a constitutional, that's the last part. I think it's the second.
Yeah, the
or
judge
third.
found facts.
Right.
Yeah.
The judge found facts and, violating the Fifth and Sixth Amendment of the Constitution. Do I believe that the facts as testified to authorize imposition of a consecutive sentence? I believe that after reviewing it, you don't even want to know how many charts I had to make sure I wasn't missing it, that the consecutive sentences are authorized by statute.
All right. So it's discretionary and Northfleet controls.
Yes. And the last comment I want to make is this Erlinger decision from the United States Supreme Court that I referenced, I think very much stands for the proposition that if a discretionary consecutive sentence is going to be imposed, then the fact that it arises out of a same transaction is a fact that must be found by the jury. Otherwise, it is a violation of the defendant's Fifth and Sixth Amendment rights, Your Honor, under the Constitution. Does the court have any questions?
No, thank you.
Thank you very much.
Thank you, and you'll have
And,
time for rebuttal,
Of course,
obviously.
thank you, Your Honor.
Mr. Schrotenboer, welcome.
Yes, thank you. May it please the court, Jerry Schrotenboer, Ingham County Assistant Prosecutor for Plaintiff Appellee. Let's go to the first issue. Now, there's always a tendency to just jump into the merits of the claim, but that's actually number 5 on the list. Number 4 is the review standard. Number 3 is issue preservation. Number 2 is jurisdiction, and number 1 is when is it due. Anyways, there was no objection here, meaning we have the plain error standard, and defendants claim that, oh, I filed a motion for a new trial that preserves it. Sorry. I recently came across a case that came out last February, Sixth Circuit. A post-trial motion is too little, too late. After trial, the district judge was no longer able to rectify any problem. So the post-trial motion did not preserve the objection. It's a case called Sittenfeld, Sittenfeld, 128 F 4th 752, page 778.
But we don't have a waiver here. We have forfeiture, right?
That's
And so
correct.
It's plain error review, and simple as that.
That is correct.
Is there an error? Was it plain, and did it affect substantial rights?
That's correct. And that's where we head, because it's plain error review. The case that I cited, McAllister, it has to strike the court as wrong with the force of a 5-week-old unrefrigerated dead fish.
That's Judge Easterbrook from the Seventh Circuit now.
Could be, but
It is.
this was a Sixth Circuit case.
He's the origin of that line.
Oh.
I think that,
Okay,
I think that standard is not widely applied anymore, even though it makes everyone chuckle.
oh, it's applied in the Sixth Circuit.
Right, but this
Oh, yeah.
isn't the Sixth Circuit.
That is correct. That is correct. And the judge said, if. You see, if there had been a problem, defense counsel would have objected. Maybe not a contemporaneous objection. It's not always the best thing to object to a judge in front of the jury, but it could have been done off with the jury out, and the judge could have said, okay, fine. I'll give a limiting instruction to,
That's pretty circular. I mean, it's unpreserved because counsel didn't object. So
Yeah.
to say that if it were a problem, counsel would have objected is not part of the analysis under plain error.
that
You don't
is,
say, well, defense counsel didn't think it was a problem, so we don't think it's a problem.
actually it is. And the reason for that is it tends to say that it's not all that prejudicial. And yes, I cited a case on that one too. US versus Warshock.
Well, let me put it this way, Mr.
Okay.
Schrotenboer. I've tried a lot of criminal cases, both as a prosecutor and a defense lawyer. I would have been out of my mind to get up and make the objection contemporaneously that you described. To
I
tell the
agree.
judge, you're doing something wrong in front of the jury, and run the risk of the judge taking my head off in front of the jury. And even if the judge didn't take my head off, emphasizing the point that this is a problem that these girls may be going to therapy.
I agree. Which is why I said the objection can come
I
when the
understand.
jury isn't there. Yes, normally we require a contemporaneous objection, but there are some issues where we don't.
Right.
For example, a claim that the verdict is against the great weight of the evidence. It's really hard to do it there. And with a judge objecting in front of the jury, but case law in Michigan says you still have to object to preserve. This is,
I understand. And I think we're all agreeing with you. It's plain error review. I don't mean to speak for my colleagues, but it sure looks like it's plain error review because there was no objection of any kind, contemporaneous or otherwise, until much, much later.
yes. And this is not plain error. And it certainly does not require a new trial. Now, on the other issue,
Why
well,
isn't it plain error?
It has to be, okay, let's see now.
Back to Judge Frank
Okay.
Easterbrook.
As this court stated in 2021 in People versus Sweenor, SWENOR, 336 Mishap 550, page 569, an error is not plain absent binding case law that has directly addressed the issue. There is nothing that has said this. Instead, a non-binding case is
Well,
mentioned.
there's plenty of published case law that says that vouching for witnesses is improper and warrants a new trial, both in preserved circumstances and unpreserved circumstances.
Well,
So it can't be that there's no published case law.
but this wasn't that. This was not vouching for them, particularly with the word if in there, and that takes care of it. Going on to the next issue. Well, the other one that's mentioned. In the first, okay. Defendant flat out says that, oh, the judge did not explain in this situation. Okay. First, the judge said that I have the ability to. Okay. And then the judge said, I can tell you that what happened to those girls is cruel and unusual punishment, and they will suffer for the rest of their lives. So that's specifically in this case. You took away their first sexual experience. You took away how they feel about men. You took away how they feel about the world, how they feel about themselves, how they see themselves. He had a threesome with these two girls. You gave them now a life of pain and constant healing, triggers and trauma. Thankfully, they have some mothers who are supportive, whatever. Anyway, it's not an abuse of discretion in this situation.
So you agree that Northfleet governs?
Oh,
You
yes.
just don't think they've come close to abuse of discretion?
That is correct.
That's fine.
And for the Apprendi issue, well, in the first place, the issue is not preserved for appeal, as I mentioned in my brief. And the second one, well, even if it were, binding case law from both this court and the U.S. Supreme Court says Apprendi does not apply. So I ask the court to affirm.
Anybody else? Thank you, Mr. Schroeder. Okay, Ms. Sharon, you have a few minutes.
I won't require all of it. Thank you, Your Honor. So just so that the court is aware, although I'm sure you are, the Stevens case is cited in my brief. That's out of the Michigan Supreme Court. So the suggestion that there isn't binding case law on the subject really should fall on deaf ears. And then also, I think respectfully opposing counsel is, so he is correct that trial counsel failed to object. And that's why the issue is raised both as its own independent issue and then also under ineffective assistance of counsel. That is the first section under the IAC portion of the brief, right? So it's made in the alternative. But also, even if you look at Hudson, which I understand is unpublished, the attorney there didn't object until the following morning, right? He says nothing at the end of trial on that day and waits until the next day. That's not preservation either, waiting an entire day to lodge an objection. But this is structural error. And so then we look to the Michigan Supreme Court case in Davis, which is also in the brief about how we assess plain error.
But why is it structural error? Structural error is an error that's pervades the entire court process. You can't be isolated in any incident. This one can be isolated in two specific instances.
Yeah, but the incidents in my opinion, Your Honor, are so offensive that they do invade the entire trial. When you have a judge, respectfully, who is outwardly biased, I mean, if one of you stood there and said, "Oh, Ms. Sharon, I think you're an idiot and your arguments are horrible," right? That would be, I mean, maybe you're thinking it, but that would be right outward bias that would deny defendant of a fair trial. And that's why I believe that this is structural error, because you have a judge who is making comments very much reflecting her belief that these girls are victims, in fact, of sexual abuse. So respectfully, I think some of the alleged shortcomings are very much all addressed in the brief, that it's structural, it is plain error. We have to look to the very recent case of Davis out of our state Supreme Court, and certainly that there is plenty of published case law on the issue of piercing the veil of impartiality. That is a tongue twister for me, and I don't know why. Your Honors, I ask that you either vacate the convictions or remand for resentencing. Thank you for your time today.
Thank you both very much. Excellent arguments as always. That case will be submitted. Schrotenboer, I think you can stay right where you are for the next three. I'll let Ms. Schroen have a moment to gather up her belongings, and then we'll call the next three cases. Docket number 367369, docket number 367373, and docket number 367376. Each the People versus AJ Bargava. And as I understand it, Mr. Herskovic is going to be here remotely, and there he is. So whenever you're ready, the lectern is yours.
Good morning, Your Honors. David Herskovic appearing on behalf of Dr. Ajay Bhargava. I just have to point out this has been one of the most interesting panels I've ever sat through. It's been very educational. So
The case is not the panelists, right?
Right. We're just trying to keep up.
Both, everything included. And I hope this case, continues that streak. So, as the court is well aware, this is an instance where we get a verdict, and following the verdict, one of the jurors finds defense counsel and the prosecutor on the case and readily and excitedly admits, I did my own research. It was a game changer.
Every
otherwise
trial
there would have
judge's nightmare.
I'm sorry, Your Honor.
Every trial judge's nightmare.
Exactly.
Who refuses to follow the instruction about not doing outside research.
And as Your Honor just stated, there is an explicit instruction to the jurors, which was given, that they are not to do any outside research. And yet here, the juror explicitly did that. And she did that because prior to that, by her own admission, because there was an evidentiary hearing, her intent was to prove innocence. She was one of the three jurors who was opposed to a guilty verdict during the initial determination by the jury. And she did her own research on Larry Nassar, which was a point of contention in the case as to the attention that case had gotten. It was the same police department, the Meridian Township Police Department, that was investigating Dr. Bhargava. And she wanted to check the timeline. She was hoping to prove her innocence. And by her own admission, after doing that research, realizing that the timeline of when the complaining witness in this case, Ms. Coggins, made the accusation was before the Nassar 60 Minutes episode, that in essence changed her mind. And she admitted this to the attorneys following the case. Now,
but just to be clear about that, it sounds to me as if she was disinclined to go along with the majority. The majority wanted to convict. She did this outside research, went to the others thinking she would persuade them. And instead, in the long run, they persuaded her, which is what deliberations are supposed to involve, right?
yes, but nonetheless, she still did research, and by her own admission, it changed her perspective. Now, at the evidentiary hearing, she does state three other reasons, but that was a year after the trial had already concluded.
So with respect to, it changed her perspective and kind of piggybacking off Judge Yates. Her own research showed her that the complainant came forward before the 60 Minutes interview. But so in that way, it affected her credibility analysis of the complainant. But she attributed her ultimate vote to Judge H's point, to deliberation, and she named two other jurors specifically and cited prayer as the reason she ultimately came to the conclusion she did.
That is correct, but that's not the reason she gave initially when she had her initial excitement, her excited utterance in hearsay terms. Her initial reaction was only, this was a game changer for me. I was not guilty until we saw this, and then until I saw this, and then, boom, I decided to go not guilty. Again, we have to, oftentimes in trials, you'll have defense counsel questioning witnesses as to their story change from preliminary exam to the trial. And the question you will always get from an attorney is, was your recollection clear, closer to the event than it was a year following? So in the same rationale, her initial excitement was all about this one, this research. That's why it's changed her mind. I understand there are statements a year later that kind of mitigate that, but we have to take into account the initial statement. I think it should hold more weight than a reasoned explanation a year later, after having spoken to a private investigator and even given more time to determine what her rationale is, so as not to screw up a jury verdict, which she could have in essence done because of her refusal to listen to Judge Kennedy's explicit orders to the court.
Here's the difficulty I have. So the complainant that she said, that juror 13 said, okay, so juror 13 does this research and it affects her feelings about one particular complainant. That complainant herself testified that part of her motivation for coming forward, one part of it was having a child and that responsibility motivating her to come forward and, make the world a better place for her child. But the other part was, well, there was a lot of news media going on about Nassar, and it sort of triggered this responsibility in her to come forward. So I struggle with the idea that looking up news coverage that the complainant themselves cited as part of their reason for coming forward would rise to the level of, substantial likelihood of altering the jury verdict. Does that make sense? So even though
substantial possibility, Your Honor.
Go ahead.
It's out of butts, and it's a substantial possibility that the influence
right
could have affected the jury's verdict.
If the complainant's testimony itself, albeit perhaps not clearly remembered by juror 13, cites to news coverage as part of her motivation for coming forward, and juror 13 looks up news coverage
against the orders of the court.
Correct. I don't think there's any question that what she did violated the orders of the court. That I don't think that's a question for anybody. I just think it's that last part, the substantial likelihood of altering the outcome. If if the complainant themselves testified, hey, I was partially motivated by the coverage of the Nassar case to come forward, how do we get past that?
We have to take into account, Your Honor, that the juror, Miss Reynolds, admitted that she does not watch TV. She hardly listens to the radio. She doesn't have a computer in her home. She had to look this up on her phone. She's an admitted hermit. So, whether or not it was on the news and Miss Coggins saw it, it isn't as important as Miss Reynolds doing the research. The other thing too we have to take into account is, by Miss Reynolds' own admission, she did not find Miss Coggins initially to be credible as a witness at all. And it was only after she did the research, she went and looked this up and saw the interview, that her perspective changed. So if we're relying on the witness's testimony, we also have to rely on the fact that the juror didn't exactly have the highest opinion of the witness prior to doing that research.
At the evidentiary hearing, and maybe I'm misremembering, I thought juror 13 testified, I would have voted guilty regardless of my research.
She did say that from questioning from brother counsel, yes.
Okay.
But again, I go back to the notion of her initial reaction wasn't oh, I had to come to Jesus moment, or, Juror William and I can't remember the female jurors' names.
Was less measured and less nuanced than her testimony. But the
Yes.
initial reaction is what the court uses to say, hey, we need to have an evidentiary hearing on this issue, and they do. And then at the evidentiary hearing under oath, she says, by the way, I would have voted guilty regardless. I think that sort of makes it really difficult to find that her external research altered the outcome of the trial. And this is understanding, to your point, one juror makes or breaks the case. I understand all of that. But I think that specific testimony is particularly difficult to overcome for
But
you.
it was still one of her reasons. She listed 4 reasons for changing it, and one of them was still that she did the research, and because of that research, it changed her perspective.
And said, so she lists 4 reasons, and then his question, would you have voted guilty regardless of your research? She says yes. Right?
Again, I mean, she, had a year to ponder being asked that question. So, I mean, we've made the argument in the brief. I would rely on what we stated in the brief in furtherance of however else I've answered your question. I hope I've answered it satisfactorily.
You have. Thank you.
If there are no other questions on that issue, I just want to reference the second issue, that being the expert testimony. It is our contention that an objection was made as to regarding inappropriate expert opinion. Detective Payne offered a statement, and by brother counsel's own admission in his brief, that this was insider information. And to me, insider information specifically speaks to expert. If you're going to a library and you're hoping to get a book from the general fiction section, that we consider common knowledge. That would be a lay witness. But if you're sharing information retrieved from the special collective section, that requires special training and access to get into, then that would dictate that it be properly labeled as an expert. And because Detective Payne wasn't qualified as an expert to offer the statement that it is a propensity in a way, was offended Dr. Bargava's due process rights to a fair trial. And beyond that, if there are no other questions, I would rely on my brief and reserve some time to respond to any arguments brother counsel may make.
Thank you very much, Mr. Herskovic. Anybody have any other questions for him? Thank you very much. Mr. Schrotenboer, welcome back.
Yes, thank you. May it please the court, Jerry Schrotenboer, Ingham County Assistant Prosecutor for Plaintiff Appellate. I will be brief. We know what the standard is. 2 steps in Budson. The first step is met, of course. That's why we held the hearing. The second step is not met. Defendant relies very heavily on the statement made earlier. That one was not made under oath. She testified under oath as to what she would have done. And in addition, it goes back before the evidentiary hearing. The affidavit that defendant submitted had her own handwriting in there saying there were 3 other reasons for it. The trial court is in the best position to determine what influences what. This is to a certain extent a credibility decision. The judge made it, and I ask the court to affirm.
Anything from anyone? Thank you very much, Mr. Schrotenboer. Mr. Herskovic, you're back up sooner than you expected, I imagine.
Oh, much sooner than I expected, Your Honor. The only thing I can respond is that, yes, the affidavit wasn't taken under oath, but she admitted at the evidentiary hearing that the statements within the affidavit, especially regarding the game changer comment, were accurate. So I would leave it at that.
Thank you very much. All 3 of these cases are submitted simultaneously. And that brings us to the end of our 10 o'clock session. We're going to take a brief break now, but for those of you waiting, I can assure you that we only have 4 more argued cases to go. So this morning we were able to get through 7. We're down to 4, and so we'll be able to get you on your feet fairly quickly, and we look forward to hearing from you. Thank you very much.
Honorable Court of Appeals of the State of Michigan is now in session. You see it?
Thank you for your patience, everybody, and we're now ready to hear from everyone who remains in the courtroom. The next case on the docket is case number 8, docket number 371839, Clark Commons Limited Dividend Housing against 67-5 District Court Judge. And let's see, I want to make sure that we have Mr. Weitzman on. He's appearing remotely, so if you could just hang on for a moment. I presume you're Mr. Cox?
That's correct, Your Honor.
All right, thank you very much. If you wouldn't mind being patient, I'm sure we'll have Mr. Weitzman with us in just a moment. Or maybe not.
No,
There we go.
Barney Weitzman here. I'm here, Judge.
Hello, Mr. Weitzman. How are you?
Good. How are you?
Very well. Thank you very much. All right. Mr. Cox has taken the lectern and you may proceed when you're ready, Mr. Cox.
Thank you, Your Honors, and good morning. May it please this court, Aaron Cox. I'm appearing on behalf of the petitioner appellant in this matter. This morning, I have the unenviable position of asking this panel of judges to tell a circuit court judge, to tell a district court judge to follow the law. And while I understand that the request is a great one, it is one that under these circumstances should in fact be granted. I will, if the court will permit, reserve a few minutes for rebuttal.
Of course.
I will be very brief because I think that the issues that are actually before this court are quite narrow. This is a complaint for superintendent control. The circuit court judge in Genesee County dismissed the petitioner's complaint, finding specifically that the ability to file a complaint with the Judicial Tenure Commission against the complaint of judge constituted a quote unquote adequate remedy under the court rule that barred the circuit court from rendering a decision on the superintendent control complaint. That finding is pursuant to every published opinion as well as the court rules themselves, an error. An adequate remedy under all of the case law and under superintendent control very clearly says that it has to not only be a remedy, but a swift remedy. And I think the court, this panel can take judicial notice that a judicial tenure complaint, to the extent one is ever even made public, is generally speaking not a swift remedy. The swift recovery or outcome of a judicial tenure complaint, even when they are actually investigated, is generally the exception, not the rule.
Well, let me talk to you a little bit about the breadth of the request you're making, Mr. Cox, because we Court of Appeals judges get requests for superintendent control all the time on our motion panels, and we turn down almost every single one of them, except for the ones where there's really something discrete to be ordered. For example, if a judge has been sitting on a motion for a very long time, we'll direct that the judge decide the motion within a certain number of days. Here, what you seem to be concerned about is so sweeping, it's hard to even write an order of superintendent control that tells the judge what to do. Stop asking tough questions when people show up at hearings. Stop adjourning hearings. Stop ruling against landlords all the time.
I understand the court's question, and the Summary Proceeding Act, which is really what this case is about, and it's about Judge Maribel's handling of summary proceeding cases before him. The Summary Proceeding Act under Michigan law is a very unique creature in our jurisprudence. I don't think, I finally get to be the old guy that says I'm doing this for almost 20 years. I don't think in my 20 years of practice, I've ever come across another area of law that has both a statutory scheme and a court rule scheme that directs exactly how, when, and where the cases are supposed to be adjudicated, like the Summary Proceeding Act, because every single stage in the Summary Proceeding Act, from the filing of the complaint to the issuance of the summons, to the first hearing, to trial, to the judgment, to the order of eviction, every single step in that process has a finite date that is attached to it.
Right. It's supposed to be a rocket docket. That's how it was designed.
And our Supreme Court has said as much in Jam Corp versus Aero Disposal and Sewell versus Clean Cut Management. Our own Supreme Court has said summary proceedings are quote unquote swiftly moving. And to your point, that's exactly what these things are. And when you have a sitting district court judge who is frankly openly disregarding both the legislative dictates of those time periods and the court rule dictates of those time periods, it is appropriate for this panel and the circuit court to tell that district court judge in such a broad and sweeping order, you have to follow the rules, because he's not.
Right. I mean, I will say it's extraordinary that you're even standing here today, because when we grant, it means we're looking closely at a situation, and this is not common. I've been here 4 years. This is the first superintendent control argument I've seen. So I want you to understand that we are taking very seriously the claims that you're making.
Well, and I appreciate that, Your Honor, because there's, again, this for what better or worse is my life in terms of what I do for my practice, and summary proceedings are generally not something that makes its way to a panel in the Court of Appeals for any determination. Generally speaking, because the courts follow the rules, and to the extent that there are issues, they are appellable issues, and that one appeal can correct the action. That doesn't exist here. And I do just want to point out, there are two segments of what we're asking for, right? I think both should be granted. The first one is very clearly the circuit court finding that a judicial tenure complaint is an adequate remedy was erroneous. I did cite in my reply brief, I want to repeat it here, our own court rules in MCR 9.211B specifically state that the JTC's office is not there to quote unquote exercise superintending or administrative control of a court. So if our own court rule recognizes that that's not the JTC's job, then it can't be an adequate remedy for the circuit court to determine. And then the second part of it, Judge, is I think that this panel, because again, I recognize the difficulty of asking a circuit court judge in Genesee County to issue an order to a Flint district court judge to tell him what to do. I recognize how difficult that ask is. I think it is more appropriate coming from this panel to do that and tell the circuit court judge, no, based on the facts that were before you, superintendent control as requested by the petitioner was appropriate for all the reasons that were laid out in the motion for summary disposition. And not only should this panel reverse the circuit court, but it should remand with an instruction to grant the requested relief.
Just to be clear though, and I was double checking to make sure I'm right, this is abuse of discretion review, right? I mean, it's not plenary review.
Well, Judge, I actually think that it's a de novo review because we're talking about the interpretation and analysis of the law and the court rules.
Okay.
So I don't think that it is an abuse of discretion, but to cite, a prior arguer before you, right, that abuse of discretion standard, it stands out to us in this case because it is so outside of the range of normal and principled outcomes, because the law and the court rules are very clear that it is not an adequate remedy that can bar the circuit court from granting relief.
So your argument as to why the JTC is not an adequate remedy under the court rule is because it's not swift as required under case law?
That's part of the argument.
Okay.
I mean, that is in Hague and Cahill versus Thomason and City of Detroit versus Recorder's Court Judge. All of those cases are published opinions that tell us that if you're seeking not an individual case change, but you're actually seeking to correct the systems, processes, and procedures of the lower court, that the only adequate remedy is superintendent control. Henry Hague specifically tells us that it can't just be a solution. It's supposed to be a swift solution to the problem, but that's the law side of it. The court rule itself tells us, 9.211 subsection B says that the JTC's office is not intended to exercise superintendent control over a court. So the combination of the two is my answer to Your Honor as to why it cannot be an adequate remedy.
Does the public versus non-public nature come into play?
I don't have a case to give you or a court rule to give you, Your Honor, so I'm going to just give you my opinion on this. I did file a judicial tenure complaint against Judge Maribel arising out of the very facts that are the basis of this action, right? And that complaint was filed approximately a year and a half ago. I've never heard more than we've received it from the judicial tenure office. I've never been told whether or not they're actually formally investigating it, whether they've dismissed it, whether anything's been done with it. And I think this panel would recognize that, with the exception of a couple of very public JTC complaints against sitting judges that have come down in the last few months, generally speaking, and I say this with all due respect to our system, judicial tenure complaints are kind of dealt with in the shadows of the judiciary. They're purposefully not public because we are protecting the judiciary, and appropriately so in most cases, from frivolous complaints. So all of that is my way of saying no. I mean, it's not fast. It never is fast. The only time that you see something that happens swiftly from the JTC's office relative to that complaint is if it's something that is just so incredibly egregious that it has to be corrected immediately.
Yes, they can certainly move quickly if they must.
Yes.
And, but my original question was public versus non-public. So you talked about waiting a year and a half, which speaks to swiftness, but waiting a year and a half and knowing nothing, which speaks to public versus non-public. Does the fact that the JTC is relatively non-public in nature, is that a relevant consideration in deciding whether this remedy is adequate?
I don't think that it is, Your Honor. I don't think whether it was a public or not or non-public determination would impact the outcome, because the question is whether or not the circuit court had the authority to grant the relief. And the circuit court just said no, because you go let the JTC's office deal with it. And I just very clearly think the law and the court will say otherwise.
Thank you very much, Mr. Cox.
Thank you.
You'll have time for rebuttal.
Thank you.
Mr. Weitzman, it's the floor.
May it
is yours.
please, sorry, may it please the court, Barney Weitzman, assigned by Genesee County to represent 67th District Judge Maribel, appearing on his behalf. I'm sorry that I'm on Zoom. I'm recovering from surgery. I would much rather be in the room with you all. I have to immediately just make some remarks outside the scope of my organized remarks in response to what Brother Counsel said. First of all, he hasn't mentioned the fact that 5 out of the 6 cases, and he's only relying on less than 0.5% of Judge Maribel's landlord-tenant dockets during the relevant 3-year period, were within the scope of Administrative Order 2020-17, which, among other things, said that if a tenant is getting rental assistance or has an application pending, things are stayed and you don't proceed to judgment. That order also says that there's nothing in that order which takes away from the judge's powers under MCLA 600.5732, which is within that the summary proceedings set of statutes, which allows a judge to adjourn things and has that power. There hasn't been any comment made about that fact by Mr. Cox. With regard to
Mr. Weitzman, are you taking the position that the district judge is acting in near full compliance with state law?
Am I taking the position that the district judge is acting in what compliance?
In near compliance with state law, largely complying with state law.
Yes, and I am. And also, even if he's not, okay, it is not the office of superintendent control to make judgments on whether or not the district judge is correct. Okay, that's not a proper use of superintendent control. The proper use of superintendent control is when there isn't an adequate legal remedy. An appeal by definition is an adequate legal remedy, but it is not the only remedy. There is nothing in, I want to talk about this SWIFT part. Those cases that talk about SWIFT, those cases are talking about something totally different. They're not coming out and holding, this has to be SWIFT. No, what they're saying is it's improper to be fastening, and they use the word fastening, other claims, okay, to a summary disposition, to a summary proceedings because of the swift nature of the summary proceeding. Okay, that's what they're talking about. And I think that Mr. Cox is misconstruing that. With regard to Mr. Cox saying there's not a single case, or this is contrary to all the cases, I'm not aware of a single case that says that a complaint to the Judicial Tenure Commission is not an adequate remedy. Okay, I'm not aware of any such case. Okay, it's none cited in his brief. The Judge Patel, the circuit judge, cited an unpublished case, the Wabiki case, which held that the Judicial Tenure Commission has the sole jurisdiction with regard to complaints or violations with regard to a judge's alleged violations of the judicial canons. I want to proceed further. Okay, the issue of the Judicial Tenure Commission came up during oral argument, came up by me. Okay, I indicated that it was the elephant in the room. I object to Mr. Cox making statements before this court that are outside the record in this case. His comments about the Judicial Tenure Commission, that wasn't before Judge Patel, shouldn't be before you. His comments in his reply brief that Judge Marable is no bastion, because I say in my brief, supported by a verified statement, that the 6 cases he relies on are less than 0.5%. And he starts to claim that Judge Marable has been disqualified. The chief judge laments. None of that is a matter of record. Okay, none of it. And I object to it, and I make a motion to strike. It's improper. Okay, with regard to, I think that the Judicial Tenure Commission is an adequate remedy. What happens is, and I know the court knows it, but I'm going to say it: a complaint is made. Okay, the complaint is investigated. The Judicial Tenure Commission files a complaint. There's generally a trial before a master. Okay, the Supreme Court then has the power to boot the judge. And for instance, in the McCree case, okay, which I think I cited in my brief, clearly has the power to boot the judge and does boot the judge. And that's how the system works. The Judicial Tenure Commission has the power to seek interim relief from the Supreme Court. And if there's some sort of an agreement for discipline, and there's a violation, the Judicial Tenure Commission, as I indicated, can obtain sanctions. So this Judicial Tenure Commission, I mean, he's saying that he's never heard from him. Well, that's interesting. It's not a matter of public record. Okay, if it was a matter of record in this case, not public record, then maybe we'd have a hearing as to just why that is. And probably you'd be told because there wasn't a violation. Okay, if that's the case. But in any event, the violation has to be to get anywhere on the complaint for writ of superintendent control. It has to be a clear legal error. Okay. Now you're talking about, as I said, less than 0.5%. Okay. In a situation of COVID. Okay, dealing with not only the court rules and the statute. And the statute in the court rule, as I indicated, does have various provisions in there which contemplate an evidentiary hearing. Okay, but then that's more complicated by the administrative order and COVID. So, maybe nothing is clear. Okay, but for Mr. Cox to come in on this record, okay, and say that Judge Marable has violated a clear legal error is completely out of line. Judge Marable is just doing his job. Mr. Cox and his clients disagree with that because maybe they want their properties back faster. Judge Marable respects that. Okay, but it's in everybody's best interest, Judge, that the rules be complied with. Okay, and the administrative order be complied with. And that is what Judge Marable was trying to do. And if he screwed up, Judge, he made them judges. If he screwed up, it's, Judge Patel isn't supposed to consider that. That's not the deal. He's not supposed to second guess the judge. And Judge, and I'm referring to you, Judge Yates, 100% it's an abuse of discretion standard. Okay, and that is there's more than one case, but I cited Shepard.
Right. The general proposition is the decision on whether to exercise superintendent control is subject only to review for abuse of discretion.
Agreed.
Right. Now, it's also a principle that a violation of law is, by definition, an abuse of discretion. But I get your point. I don't think there's any debate to be had about the standard of review.
All right, now, another thing that Mr. Cox indicates in his brief, which is completely unsupported by the law, is that you, as a panel, should ignore all the other reasons in my motion, in my brief, and in my second amended motion for summary disposition to dismiss the complaint, okay, because I did not file a cross appeal. There is absolutely no authority to support that. In the Hawkins case that I cited that indicates that this court will not reverse a lower court coming to the correct conclusion, but for the wrong reasons. There was no cross appeal in that. Another case that I can cite, I don't know if it was in my brief or not, Taylor versus Laban, 241 Mishap 449. Again, the court reached the wrong, correct result for the wrong reason. There was no cross appeal. That makes no sense. The side that's the winner, okay, doesn't generally appeal, okay? There's nothing to appeal. You're happy with that argument isn't supported by the law and makes no sense. All the other aspects that were contained in my second amended motion for summary disposition and in my brief were independent basis to require Judge Piquel to dismiss the complaint for superintendent control, including but not limited to, aside from the fact, no clear legal error, okay? Including but not limited to the fact that Mr. Cox made absolutely no, or his law firm made no effort to serve the underlying 6 tenants in the case. Now, when you closely scrutinize the record, I know that there was a dispute between Mr. Cox's office with regard to one of the landlord-tenant cases where they didn't attach a lease, okay, where they didn't file a police report. They tried to do it on the day of the hearing, okay, and then after my case is pending in Fort Judge Piquel for months, his case, okay, and then, you know, he still hadn't made any attempt to serve these people, and his response was, well, you know, they're tenants, they're transients, just this sweeping generalization. Look, as lawyers, we know if you can't find something, first you make an effort, right? I mean, I heard a law student, a Michigan State law student, making a very fine argument in which she said, you know, it's everything, you know, you do everything that's reasonable. Okay, well, at least you try. There was no suggestion that you tried. There was no motion for substituted service. Okay, the process, as a practical matter, the process servers all have databases. Okay, and they find people that can't be found. Okay, that's nonsense. Those people had a right to show up and to be heard, and they weren't served. Okay, this is not a class action suit. Okay, so to make the argument that it's a generalized practice is that poof, it goes away. That only happens if you have a class action. Examples are the Cahill case. Examples are the Michigan Department of, go ahead.
As far as the class action goes, I understand what you're saying, but your argument as it carries over to superintendent control, I guess, is that every one of these landlords in every one of these cases has to fight it out individually and take an appeal, right? I'm not saying that that's wrong, but I mean, that's the remedy. Take
Yeah,
an appeal.
okay, my response to you is, when you say every one of these, I mean, Mr. Cox, you know, files his thing. He represents 2 landlords, okay? He's claiming that, you know, there's all these, okay, alleged landlords out there that are victims of this. They're not parties. It's not part of the record, okay?
Right.
When he makes these citations, he claims his stuff, he cites his own unverified complaint for writ of superintendent control. There's no evidence in the record. We're talking about 6 people, Judge, okay? And it's in each individual person, okay, or the landlord, in each one of those 6 cases that the landlord chose, could file an appeal. And you know, an appeal has an effect. I mean, you guys are judges, Miss Judge Young, sorry, you're all judges. Sometimes, you know, when you file an appeal, it has an effect, okay? If you prevail on appeal, the judge learns, okay? Well, there's no appeal. They could have taken interlocutory appeals. They could have taken direct appeals. You know, I practice all over the state, but mostly in Genesee County. You feel like you're getting the shaft, you file an application for leave to appeal, a motion for immediate consideration, you get the attention of the judge assigned. All that stuff could have happened. Instead, what did they do? They waited 3 years, 2 years, 1 year, okay? When all the cases were closed, sat back and did nothing, okay? And then kind of take this less than 0.5% and put it to you and ask, you know, for this sweeping relief. One thing that hasn't been noted, but I'm noting it now, based on the 2024 unpublished Court of Appeals opinion that indicated, and I have the site, that when all the cases are resolved, this is In re Rossman, 2024 WL 1596922 unpublished. When all the cases are resolved, okay, and the plaintiff had a hand in the resolution of the cases, there's no basis for it. It's moot, and there's no basis for a complaint of superintendent control. In Rossman, the plaintiff stipulated to some order, okay? But in our cases, all these cases were resolved through the efforts of the landlords, through the efforts of Mr. Cox and his law firm. It's over with, okay? All this stuff is moot, okay? And under the rationale of Rossman, and I know it's unpublished, but it's worth something, to quote you, Judge Yates, and it is, it's moot. I think that Judge Piquel, his opinion was wise. Okay, I mean, he got it. He understood the essence of Mr. Cox's argument is that Judge Marable is allegedly violating his duties, and that this is something that the Judicial Tenure Commission should handle. One of my arguments to Judge Piquel was, you're not structured. You don't have the resources, Judge, to investigate, to enforce an order for superintendent control. You just don't. If you ordered, or if it was ordered that there be an order of superintendent control, and how would it be worded, then how would it be enforced? There'd be fighting over whether Judge Marable complied with it, didn't comply with it. It would be a mess. The most efficient way to deal with it is the judgment is the Judicial Tenure Commission. And I agree with the Wabiki case that Mr. Judge Piquel cited. One other thing I want to comment on, and that is, I expect, two things. I expect that Mr. Cox is going to stand up and say a bunch of stuff that's not a matter of record. I don't want to interrupt him, okay? And I won't, but I'm just right now objecting in advance and making a motion to strike in advance. Anything he says, it's not covered by the record. I said this to Judge Piquel, and I'm going to tell this to you, or say it to you. If you order, okay, somehow Judge Piquel to reverse himself and order summary disposition, okay, you are going to be opening the gates of HELL. Okay, I'm not hearing anything from Mr. Cox about filing an appeal. I mean, as I indicated, all these people could file appeals. There's all kinds of aggressive litigators. There's all kinds of pro pers out there, okay, that sue judges, that sue everybody, okay, that maybe don't take appeals on time, and they're just going to use the complaint for superintendent control as a super appeal, okay? You're going to create more problems. You're going to create more clogging of the courts, and you're not going to benefit anyone. Judge Piquel's ruling was correct, and I asked that it be affirmed. And do you have any other questions for me?
I think not. Thank you very much, Mr. Weitzman. I appreciate it. Thanks for being here.
Thank you, Judge.
Virtually, thank you for being here.
I appreciate it.
Mr. Cox, you get the last word. You have about 5 minutes if you want.
Thank you, Your Honors. I'll try not to use it all. I just want to address some of Mr. Witzman's arguments. Judge, his argument that there's this 0.5% thing, and that because it's quote unquote so de minimis, this court shouldn't take action. Again, there is nothing actually in the record that supports that the other 99.5% of his landlord tenant cases are actually adjudicated in conformity with the Summary Proceeding Act.
Right. The only thing I'm worried about, Mr. Cox, is that if we exercise summary, if we tell the court to exercise superintendent control, typically we're telling the court to do some discrete task. And what I don't want to do is take 1 or 2 or 3 instances where there ought to be some sort of remedy and blow it up into an overall superintendent control order that suddenly puts the circuit court as the overseer of everything that happens in the district court.
Well, I don't think that that's necessarily what we're asking for, though I understand the question, right? We want an order that directs Judge Marable to comply with the Summary Proceeding Act, because that's what the law and the court rules say.
Right.
And if he complies with the act, which there is ample room in the docket for him to do, if he does it correctly, then there is nothing that the circuit court has to do. But the second that he deviates from the requirements under the statute and the court rules, the circuit court can take action to enforce that obligation. And frankly, unfortunately, I think that is the situation that is required in order to correct this. And contrary to the argument made by the appellee, the law is clear that when you are not trying to seek an individualized outcome, an appeal is not an adequate remedy when we're talking about superintendent control. And it just so happens, I was the attorney on In re Rossman. And that case argued out of Detroit dealt with a very narrow issue, which was this 36th District Court was not adjudicating a case. It was perpetually adjourning the file.
I get it. It's very hard to take an appeal from an adjournment.
So
I guess technically you could, but it'd be by application and it'd be really hard to persuade a court to take a look at something.
The difference between In re Rossman and here is we were dealing with a single issue in one case, whereas here we're dealing with a pervasive problem throughout the entirety of the docket. And I do also just want to point out the argument that Administrative Order 2020-17 somehow gave Judge Maribel the freedom to disregard the Summary Proceeding Act and the court rules is just simply incorrect. Administrative Order 2020-17 specifically told that the courts maintain their statutory authority to adjourn a case for greater than 7 days. And then it cited in that order to MCL 600.5732. That statute very simply says that a court has jurisdictions over summary proceedings, may adjourn cases in conformity with the law and the court rules. And the law and the court rules say that those adjournments cannot be for greater than 7 days unless there is good cause shown on the record. And even then they cannot exceed 56 days. That is not what was going on in these cases. That is not what goes on in Judge Maribel's courtroom today. And to the extent that this panel is not going to grant relief, I can assure you that this is not the last that you will see of this issue because it is something that is pervasive in that courthouse that has to be corrected.
Thank you very much.
Can I ask one question before you sit down? So you rely in part on the Hague case, correct?
Yes, Your Honor.
And I think the conduct there was even more pervasive than here. Hundreds of cases, I think, involved. It arose out of a JTC complaint, did it not? And if so, how does that help you?
I think that you're correct that it did, but I don't think that those things are dispositive. And I think what the law tells us is that those two things can coexist. And I think that the court rule, again, going back to MCR 9.211B, where the JTC says that it is not specifically identified as a superintending power, I don't think that those two things are in contradiction to each other, if that makes sense. I think that you can have both, that they can coexist, that the circuit court has the authority to exercise that jurisdiction, and maybe the JTC's office does as well. But it doesn't mean that just because a JTC complaint can be filed, that you can't have a superintendent control action. Because if that existed, Your Honors, literally every superintendent control complaint in some form or fashion is asserting that a judicial official is failing to abide by its legal duty. It would eat the rule. We would never have a superintendent control action that would ever survive because the answer would be the JTC's office will take care of it.
Thank you, Mr. Cox.
Thank you, Your Honor.
That case will be submitted. And we'll move on to our next matter. I think this will probably just about clear the back benches as we bring people forward for this one. This is case number 9, docket number 372252. The matter of Eric Leindecker against Ascension Genesis Hospital. So come on up if you're a part of this one. And we'll give everybody a moment to get seated and then we'll proceed with the arguments. Very well. You may proceed. Thank you.
Good afternoon, Your Honors. Matthew Turchin appearing on behalf of plaintiff appellant Eric Leindecker. I don't have much to add to our briefing today. I just want to emphasize that we understand this court's ruling in the Glaive v. Terminix case. And it's really remarkable that that appears to be the only case in Michigan addressing what a defendant's liability is for an injury that's caused by a wild animal in Michigan. However, for all the reasons that we've discussed in our briefing, we submit that Glaive is factually distinguishable as not a complete treatment of the Feri Nature doctrine in this state. And because this case is factually distinguishable, the trial court should not have granted summary disposition under MCR 2.116C8. So Glaive involved a situation where the plaintiff was trying to impose liability on a defendant who basically drove animals away from a property and caused harm some ways away, some distance away. And that's far from what happened here. Here, the complaint alleges that the plaintiff's injuries were caused by a goose attack on defendant's property, that the same goose had previously attacked other people and chased cars, that the defendants were aware of those previous incidents, and that the plaintiff's injuries occurred on defendant's property. So unlike in Glaive, where the alleged harm was remote and unpredictable, here the harm occurred right on defendant's property where they were on notice.
Right.
But Glaive doesn't talk about go ahead, you go.
No.
Yeah.
That's okay. Go ahead.
Glaive doesn't talk about predictability. It talks about it being a wild animal. And the
Right.
goose here is a wild animal. You're saying that just because it's known to be mean, that it makes it somehow domesticated?
I think it should matter. And I think that's really our point that we're arguing here is that the statements that are made in Glaive need to be taken in the context of that case, which is really quite different from what occurred here. It's not even a premises liability case, as far as I can tell. It's a strict liability action. Here we're alleging negligence claims that arose on the defendant's property or that the defendants were responsible for maintaining and taking care of. So yes, we acknowledge that Glaive does not mention predictability, but we believe it should be a part of the analysis and is consistent with the analysis that is generally applicable to invitees on a defendant's property.
But stop for just a second, because I think you've drawn a distinction that I want to explore a little bit more. It seems to me that if this is anything, it's a premises liability case. It's not a negligence case, because what you're talking about is some sort of hazard on the property, right?
Right.
And so the thing about premises liability is it takes away the negligence claims, because you have to bring a premises liability claim to the exclusion of all else. So your negligence claims against everybody are gone. But that's okay, because I think that your best argument for getting around the doctrine you're discussing is to frame it as a premises claim anyway. So why don't you try the premises argument?
Your Honor, I think that the premises argument is it's really a species of the negligence claim, and that's where we look at these.
Right. It is,
Yeah.
but I mean, it's a specialized sort of claim which has preclusive effect.
Right.
Because you can't bring all these other tort claims if what you have at bottom is a premises claim. We've said that again and again and again.
Right.
So talk about a premises claim here.
And
I mean, why do you survive C8 on a claim of premises liability?
we survived C8 on a claim of premises liability because the only basis for the trial court's ruling in this case was based on this fere naturae doctrine. And if you look at the cases that are addressed in all of the parties' briefs, they basically say that this doctrine generally only applies when you're dealing with a strict liability claim as opposed to a negligence claim, which, you know, we're just discussing the distinction between a premises liability and a negligence claim. But I think for the purposes of this analysis, they're the same. And the fere naturae.
Right. Premises liability is a hazard on the land.
Right.
You're alleging this goose was a hazard on the land, right?
Correct.
All right. And because of that, only somebody who has possession and control of the land can be subject to a premises liability claim, right?
Right.
How in the world can both of them be possessors and controllers of the property? One or the other is, right?
Right, because I've only been involved at the appellate level, so I'm not sure exactly what happened at the trial court level, but my understanding was that these claims were initially brought against Ascension. Ascension essentially pointed the finger at Teach Out, who is a security contractor, I believe.
I think, doesn't that have more to do with indemnity than anything else?
Right, and I think,
I mean, to the extent you said they point the finger, I think they pointed the finger saying, you have to cover us for this. You have an indemnity obligation.
right, and I do think that there's something to it that this was a pre-discovery motion. It's a C8 motion. We don't have any insight as to what their contracts say or who delegate. Or who
What difference is
reported.
it? Okay, I'm sorry. I do understand now what you're saying. Okay, what
Yeah.
you're saying is it's a little unclear who had possession and control of the premise.
Exactly.
All right, so you want to live to fight another day, even though it's unthinkable you could get to the end of it and they could both have possession and control of the property.
Right, yeah, and we don't dispute that that's the case, but this is a pre-discovery motion essentially, and we believe we're entitled to discovery to flesh out those issues and see who actually had responsibility ultimately here at the end of the day.
But the complaint doesn't allege that Teach Out had possession or control of the land. It does, I mean, it does definitely for Ascension. So, but not
Right.
at all for Teach Out.
Right. And I think, again, perhaps the complaint isn't as articulate as it could be or as artful as it could be.
Well,
But
this
I
is a
think that's
second amended complaint, right?
Right.
I mean, this isn't the first bite at the apple.
Right.
This is the third bite at the apple.
Right. But I do think that's the essence of what's alleged here and I think that's what's intended to be alleged here. And I think it is something that could be cured on remand if necessary. But Your Honor, it sounds like you understand the issues. I don't have anything else to add to our briefing and to the argument here today. So we'd ask that the court reverse the trial court's ruling. Unless you have any other questions, I will rest on my briefs and reserve the rest of my time.
So you agree that for a premises claim, you have to show that the premises possessor had possession and control of the land.
Right.
Here I mean, it's a little odd, but the feature of the land was a goose.
Right.
Right? Don't you, as part of that, have to show that they not only had possession and control of the land, but of what on the land made it dangerous, meaning the goose? And is there any evidence or even allegation, since this is C8, that either of these defendants had possession and control of the goose? And is that necessary?
Well, I don't think it's necessary because I think we can allege that they had possession and control of the land that the goose was sitting on. I think it's a situation where the goose was nesting in a particular spot. It's not like it was roaming around the land. I think they were aware that it was in this one particular place, and that is what our understanding of the facts with respect to these previous reports of goose attacks on the property is that it was in this one particular place. So it being a fixture in that one spot, I guess, for lack of a better description, would make it a feature of the land. And I don't think it's material as to whether the defendant had possession and control of the goose. We're not asserting that they were, keeping the goose as like a pet or a zoo exhibit or anything along those lines.
Thank you.
Thank you.
Good afternoon to the panel. Ben Teague on behalf of Appley Teach Out. Just very briefly to address some of the arguments, would definitely contend that Glaive still controls this case as far as it being a public decision and one of the very few decisions on the Feri Naturae doctrine.
Well, stop for a second though, because I don't think a negligence claim can survive regardless of that doctrine, because you have a premises claim here, and a premises claim essentially wipes out your ability to bring any other kind of claim. So it seems to me that even if we think that that old case, which isn't binding, doesn't apply here, it seems to me you still get out completely unless there's something in the pleading that establishes that you had possession and control of the land. And I'm not seeing that. Judge Young alluded to it, and I agree with her.
Yes, Your Honor, we did make that argument in the alternative that based on it's a C8 motion, and based on the allegations in the complaint, there was no allegation that Teach Out, the separate entity, did have possession or control of the land. So I would definitely agree with you there.
Yeah, it'd be a weird situation to have a security company that would have possession and control of the land.
I don't disagree.
You don't have to cut the grass. You don't have to fix cracks in the sidewalk. I mean, you're there for one specific purpose.
Yes, I would agree, Your Honor.
I mean, unless your contract's a lot broader than security contracts, I would imagine exist.
Well, I can't speak to that, and that's not in the record, as we're just on C8. And based on the allegations in the complaint, there aren't any allegations that Teach Out itself had possession or control of the
We
land.
can look to all the pleadings under C8, and if there are contracts attached, we can take a look at those. And I'm sorry, I haven't gone back and looked at it, but you have cross claims against each other. Is your contract contractual document or contracts in the record somewhere?
I don't know the answer to that, Your Honor.
Okay. I think further counsel saying that they are. Okay, so in other words, if we decided that it mattered a great deal, we'd have the ability to look at those documents because any contract attached to a pleading is part of the pleading itself.
Yes, Your Honor.
Okay.
Beyond that, we've touched on both of the two principal arguments in the brief. Definitely would argue that Glaive controls, whether we look at the Feri Naturae doctrine, being a wild animal, or strictly digging down to possession or control as a premises claim. So requesting that this court affirm summary disposition for defendants. Happy to answer any other questions if the court has any.
No, thank you.
Thank
Thank you
you,
so
Your
much.
Good afternoon, Your Honors. Richard Smith on behalf of Ascension. May it please the court, I really don't have a lot to add that has not already been extensively briefed by all the parties in this case in our appellate papers. I could address the issues about possession and control if you like. I can tell you there is a cross claim for indemnity based on a contract, and I could even give you the basis for that if you like.
Right. Well, as far as indemnity goes, obviously, if you both walk, indemnity is not of any consequence here, so we don't have to worry about it.
We'd be seeking indemnity for nothing, right?
Right. Unless it's for legal fees incurred. Is that part of it? I mean, do these cross claims survive even if C8's appropriate?
I mean, likely not. Yes, you're right that it could potentially include defense costs, but not likely. There's not a lot invested in the case at this point. We've taken a plaintiff's deposition and a few other things, but.
Okay, and I saw you nodding, so I want to ask you for the record, those contracts or that contract, is there one or are there several?
There's one contract with this particular security company.
Okay.
And the reason for that was because there was an allegation that a complaint was made about the goose I think 2 weeks before, and they failed to act on it, is the theory.
Right.
And yes.
And is that contract attached to a pleading? Because under C8,
Yes,
you
it is.
can
I
look
believe
at
it is,
pleadings.
yes.
And a contract attached to a pleading by court rule is a part of the pleading.
Yes.
So
Yes.
if we need to dig into this enough to try to figure out who has possession and control of the property, we have the ability to look at the document that would define that.
I guess I would say to you, and I hope I'm not making an admission on the record that's different than my trial strategy would be, but this is an Ascension Genesis Hospital. We're in possession and control.
Oh, okay.
I mean, I'm not questioning that.
Okay, good.
But
That
there
helps
were
a lot.
acts of negligence committed by Teach Out, the security company, that triggered the indemnity clause. And so I named them for non-party fault. Plaintiff brought them in as a party thinking we'll get them to.
I got it. So thank you for that concession. That's actually very helpful. I mean, I would have assumed that your client is the one with possession and control of the property.
I think your assumption is fair.
All right, because it seems to me that the way a premises claim works in Michigan, if you have a premises claim, you can't go bringing all these separate negligence claims. I mean, that's something that we have nailed down in about 4 published opinions in the last 4 years.
Yeah, I think the Foltz case pretty much closes the door on contract claims against snowplow companies and such, and this would not be necessarily that much different. I certainly get your point.
Right. I mean, I sat on a panel last summer where somebody slipped and fell in the parking lot of a bank branch. And not only did they try to sue the bank on a theory of premises liability, they had negligence claims against everybody, the person who installed the curb, the person who didn't put the lines down, the architect, on and on and on. All of that just wiped off the ledger because there's a premises claim, and that's all you get. You don't get a negligence claim.
Correct. It always goes back to the party possession and control. Okay. And then can be unwound by either through contract or otherwise in the performance of whatever contractual duties or services that were provided by that other entity. It was not a possession and control.
And I take it you concede that they have attempted to plead a premises claim against your client, whether they've effectively done it or not. They've tried, right?
Yes.
All right. So tell me why the premises claim against your client doesn't survive CA.
Very natural applies regardless if it's a premises case or not.
Okay.
And I mean, really think about it. I mean, I really like Judge Boontzer's argument, or maybe question, I would say, or not necessarily an argument because you're not on this side, that it is not an inherent part of the land when you have a transitory, migratory animal that passes through the land.
This seems kind of territorial, this goose. I don't
Well,
think it's transitory.
I mean, we've been talking about this goose, and I'll tell you funny thing, that somebody after this occurred took a photograph of this goose. And I mean, this is an 8x11 photograph that looks like it should be posted in a post office for the, top 10 wanted people. For all kinds of horrendous, actions. So we have this 8x10, but I took the plaintiff's deposition while this motion for summary disposition was pending. And plaintiff doesn't know if this is the same bird. He doesn't know if it's the same goose. Nobody knows if it's the same goose. Nobody can tell the difference in the way the geese looked. So, we have this, and I think this really goes to why Fairy Natural has to apply in premises cases as well. Not only is it not an inherent part of the premises, but when you think about what I heard the comment made earlier, unlocking the gates of HELL. Oh my gosh, talk about it in terms of Fairy Natural don't apply here. So knowing that birds fly over, take the nest out. Knowing that birds fly over,
Right.
and potentially, because that's what this bird did, this bird dive bombed the plaintiff. Dive bombed, knocked him off his balance, and then he fell and broke his hip.
All right. I get the argument you're making in the context, for example, of a childcare center where some huge bald eagle flies over and picks up a child and takes off and the child is horribly injured. But that's not what we have here. We seem to have a goose that's decided to lay waste to this place and hang around for a while. Again, I know you're saying it might be a different goose.
Assuming it's the goose.
The goose, not a goose.
Okay, but still, that doesn't take away the transitory migratory properties associated with a bird that does not belong to the hospital. When you look at Glaive, it says that wild animals are the dominion of the state and the DNR.
Right.
And okay, so there's a nest with eggs inside it. So remember, these are all governed by DNR, and no individual premises owner has the authority by which to remove that nest. That is all governed by DNR regulation.
I'm glad you brought that up because I have a cottage on a lake and we had a meeting of all of the lake members and there was a great deal of complaining that caused this meeting about goose droppings all over the place. And we're trying to figure out what to do. And somebody said, just give me a shotgun and immunity and I'll solve your problem.
There you go.
But you're right. You can't just go kill a goose.
No, you can't. And so
you have to escort it off the premises or something.
You could expand the logic behind Fairy Natural as applies to premises liability even further than that. How many of us know about deer that gallop through property?
Sure.
How many of us know about bears in the area? There's that one case, I think, that was cited by one of the appellate papers by Brother Counsel, and it dealt with the Alaska case. But the gravamen of that case was you created a open refuge of waste that allowed bears to come in, and that was an exception that Alaska carved out. But none of that is alleged here, and for rightful reasons, there isn't any fact supporting that. But can you just imagine the breadth of the duty that you would be placing on a premises owner if Fairy Natural does not apply? That's all I have, unless you have anything else for me. Thank you very much.
Thank you. Okay, Mr. Tigay, you get the last word.
I just have to say that every time I pick up this file, I see that mugshot of the goose that we attached to the complaint. It does give me a chuckle. I know that's bad because the injuries we've alleged here are somewhat serious, but
I know that's absolutely true. We can't lose sight of that, but
yeah,
I understand.
So I get it. There's a little bit of humor here, but I just want to clarify, I'm not advocating in any way for some kind of sweeping rule that would impose liability for any and all animals that are just.
Well, that's what I was going to say. We're at C8.
Right. Right. So all I'm suggesting is that we have I think probably a unique fact pattern here where my client was told by hospital employees that, hey, this goose has been on this property. He's been harassing people. We know about this. And so that's why we're alleging that or arguing or taking the position that there should be some kind of exception here that allows us to pursue a claim when a defendant is on notice here. And here it's admittedly on notice that this goose has been an issue and we should be able to inquire as to what's been done about it, engage their culpability. And also I do acknowledge that there's been some limited discovery that's been taken after these motions were I think concurrently with these motions being briefed in the trial court. I do object to the extent that any of that is discussion of any of that's coming in at this stage, because this appeal does involve just a C8 motion. And the discovery issues were not before the court when the motion was decided. So I don't think that's proper. But that's all I have unless there are any further questions. I'd ask that the court reverse the trial court's decision.
Thank you very much. Thanks, everyone.
Thank you.
Yep, thank you. This case is submitted. And now we're moving on to cases where we do not have contested arguments. Case number 10, docket number 372375, Evelina Skowron against Mariusz Skowron. I apologize if I've mispronounced anybody's name. My Polish is terrible, and so I apologize if your client is here, Ms. Pillman, and offended by the way I said his name.
I think you did a fine job, Your Honor. Good afternoon. May it please the court, Amy Spillman on behalf of the appellant Mariusz Skowron. I intend to primarily rely on my brief, but just want to highlight a few pertinent points. And first and foremost, among the errors that highlighted in the brief is the breakdown of fundamental due process protections and repeated violations of appellants' due process rights. This started at the outset with the treatment of the initial motion itself at the referee level. The motion was nothing more than a motion to impose 3 minor parenting time conditions, but it transformed into a vehicle that led to the supervision of appellant's parenting time, a drastic reduction from equal parenting time to supervision 1 hour every other
Did that
week.
change the custodial environment?
It absolutely did change the custodial environment. That was never addressed by the referee, and it was not addressed by the court who had another hearing subsequent to that.
Well, right. And you talked about the subsequent hearing. This was a full-blown hearing, 9 days evidentiary hearing.
I'm talking about the hearing before that.
Oh, I'm sorry. I'm
Yes.
sorry.
Yes. So before that evidentiary hearing, there was this other hearing before the judge that led to the supervision. So it was
I got it.
incrementally reduced
Right.
from
Yep.
the equal parenting time. So I kind of maybe pushed
So
it all
let's say
together
we
there.
agree the custodial environment was changed. The process that your client was due was not provided. We, to Judge Yates's point, have had this, 9-day evidentiary hearing. So, Beretta, the case that, you rely on, that big hearing was underway and the remedy was, okay, continue with that, with all deliberate speed. Here, that is done. And not only did the judge analyze under the lower standard as if custodial environment wasn't changed, the judge went as far as to say, and if I were to look at this under clear and convincing, it also meets that. So even if we agree with you about the due process issues, what is the remedy?
The remedy is to vacate and remand before a different judge, Your Honor, because you can't just ignore the import of violating someone's due process rights so substantially that the judge was clearly influenced all along the way by what happened at that hearing before the 9-day evidentiary hearing, where secret documents were submitted to the court and not provided to the appellant until 30 minutes before the hearing. He had no idea what was going to be waiting for him when he appeared for that hearing, where new allegations were alleged, where the judge heard no testimony from the parties, where the judge was clearly influenced by what was presented without knowledge, my client's knowledge, and his parenting time was completely taken away from him for 9 months, basically. That had an influence at every level of this case because the judge relied on statements and impressions that she had during the course of that evidentiary hearing. So that harm could not be undone. It was pervasive, and we believe that it showed tremendous bias against him.
Right, but one of the problems you have, Ms. Spillman, and it's always seemed unfair to me, I was a family court judge for 4 years, but the law is really clear that the custodial environment can change in conformity with a court order, in conflict with a court order, in the absence of a court order. I mean, you can have the worst example of parental alienation ever, and it becomes a factor to consider later, but the custodial environment has changed.
Well, I don't know that it had, because the testimony,
But I mean, it has as of now, even if we were to send it back again, the custodial environment has to be considered on the day that the hearing takes place. We don't look back in time. The Supreme Court's told us that. It's really clear. It's the day the hearing starts. And the day the hearing starts is going to reflect the reality on the ground today or sometime in the near future, not what it was before, right? I mean, I know they were at
Yes, that's-
50-50 at one point, but they're nowhere near that now.
well, but I don't know that that means that there still isn't potentially an established custodial environment with both of the parties. It depends on the relationship right now. It would depend on what's happened in the meantime. And so to your point, I don't know that we can say just because the children spend more than 50% of time with mom, that means that the established custodial environment was with her. I've had.
Right. Well, it doesn't mean, it certainly means that it is with her, but it may not be exclusively with her.
Correct. Correct.
Right. I mean, it's never been the case that he's had the exclusive custodial environment.
That's never been argued.
Right. So on his best day, there's a custodial environment with both parents. On his worst day, there's a custodial environment only with their mom, right?
I believe that's true. Yes.
Okay.
And custodial environment to piggyback off this is the physical location of the children, but also who they look to for guidance and things of that nature. The record here reflects that at least one of the two children looks to dad. The record also reflects that maybe in part because of some manipulation that was happening by way of text messages and things of that nature. To what extent can the court, it seems like the court took that into account in determining custodial environment. Can you take into account why a custodial environment is, or do you just determine what it is and then down the road, like with best interests, you start looking at parental alienation and things like that? And if that doesn't make sense, just tell me.
The question is, can you consider how that custodial environment came
Yes.
to be?
Yes.
I think what Judge Yates just said, it doesn't really matter if it's in violation of a court order, it still can be an established custodial environment. I think the why doesn't necessarily matter.
Sure. But I think Judge Young is right with the back half of that when you start considering the best interest factors, then parental alienation matters a great deal.
It could if that's what's happening, but
anything like that.
Sure.
That's where you put that evidence. You don't put it in the analysis of whether there's an established custodial environment.
I don't think so. I think you have to start with the established custodial environment and then you proceed to the best interest factors. And none of that analysis happened prior to the, I would not call it suspension, but the restriction of my client's parenting time or
Right.
the
But
appellant's
at the end of the day, I mean, you have to concede that there was as full-blown a hearing as there could ever be on this, 9 days.
There was a hearing after those two initial hearings, yes.
And there's no reason to conclude from the record that the trial court wasn't engaging in de novo analysis, if you will. It wasn't finding itself bound by anything. It was taking the evidence before it developed over the 9-day hearing and making determinations about the best interest factors, right?
I don't know that I would necessarily agree with you respectfully because the court was so consumed with the text messages and the information that it received prior to the start of the hearing that is the only thing that, I mean, I think the trial court said at various points in the hearing, I'm looking forward to hearing this testimony about these text messages.
Well, right. But when you talk about the text messages, I think that the court was even pretty careful about that because initially, as I understand it, the mother was the one who was translating the text messages. But eventually the court said, no, we're going to need a transcript. Let's get somebody who is an objective.
Because
translator.
appellant objected to it, because it's hearsay. And then that decision was held against appellant for requiring the translation, which turned out to be substantially similar.
Right. You're talking about the attorney fees, right? That when you say held against.
I'm not, well, yes, but also it goes to the bias that the trial court had against the appellant from the get-go, from that
How is
night.
it bias if someone says, I object to the accuracy of these, and then someone who is fluent in Polish objects to the accuracy of text messages they themselves sent, and then a third party translates them to find out that they are in fact accurately translated or overwhelmingly accurately translated by mom, how is the trial court not to take that into account when assessing, at the very least, dad's credibility?
Because it's not the only indication of there being a prejudgment against him. It started in that September 27th hearing where before anyone said a word, the trial court indicated, I find that there's parental alienation. It started in her accusing him of perjury for statements he did not make, that the transcript bears out that he did not make. It continues with her accusing him of asking his, or alleging that he asked for his parental rights to be terminated, where he merely was completely overwhelmed by what had happened at that hearing, and his legal custody is taken away. His parenting time is reduced to supervised parenting time. He's completely blindsided by what had happened, and he makes a statement in his less than accurate English about resigning from parenting time. And that is repeated in the court's determination that he lacks, I don't remember which best interest factor it fell into, but somehow that is used against him as an indication that was created by the court's process and not following the appropriate due process provisions that would have given him an opportunity to know what was happening and to prepare for it and perhaps get counsel. And he asked for time to do so and was denied. And all of that continued to influence her assessment of the testimony and the best interest factors all along the way.
Well, play this out for me though, Ms. Spillman, because I want to understand what you're asking us to do. It sounds to me as if your argument is, sure, this judge sat through 9 days of a hearing, took all the testimony and reviewed all the evidence that was submitted, made a decision, but now if we send it back, that judge can't be the one who picks up the ball and runs with it again. That seems crazy to me.
Well, it's on new facts. And I think it would be important that a judge who has already a negative disdain for the appellant not be entrusted with the decision of what happens next. But I also have an issue with the fact that all of this came from a motion that never met the threshold issues of should there be a change of custody.
I get that, but I'm asking you now to tell us how to write the order you want. And if you want an order that says it has to go back to a different judge, you have to say more than, well, this judge made a decision we disagreed with. That isn't even remotely in the same neighborhood as something that requires sending it back to a different judge. That is about the most dramatic thing we can do. To say to a judge, you are so unfair and biased, even though you've had no contact with this case other than when you were wearing a black robe, you're still so biased that we can't let you sit on this case anymore.
Well, I think that is what happens when there are due process violations and when there are such expressions of lack of impartiality that I don't know how you escape that in future proceedings. I mean, we've had proceedings while this appeal has been pending, and it is a challenge. So I think that's the remedy when we're faced with this kind of process. Okay. We needed there to be at least the appearance of impartiality, and I don't know that it exists with this judge, unfortunately. The only other issue I'd like to address is the issue of the guardian ad litem, because there is a guardian ad litem that is still technically assigned to this case or involved in this case. And at the very beginning, before testimony even started, the judge announced that she had received a confidential report from the guardian ad litem and refused to release it.
Do you have that now?
No, I still do not have
I thought
that.
the judge said it would be turned over after the hearing ended.
It was never turned over. I issued a subpoena to the GAL. He did not produce anything. We filed a motion. The judge wouldn't do anything with the appeal pending and still has not released it. So again, at the very outset, the trial court has the secret evidence that we're entitled to have and refuses to give it to us. I think this case is similar to the Patton v. Patton case, which is an unpublished case because there was Also, confusion about whether it's a guardian ad litem or a lawyer guardian ad litem. I think the judge's actions in this case indicate that she considered him a lawyer guardian ad litem, but the order of his appointment would say otherwise, and that really affects, I mean, she announced that he can't testify because I assume because she thought he was a lawyer guardian ad litem, but that's not what his order of appointment says. And the order of appointment says he has to give all the parties his reports, and he didn't. So even worse than in Patton, where they actually did get the report eventually, we haven't gotten it. The order says we're supposed to have it, and the judge refuses to order it released.
Okay, well, and thank you, Ms. Billman. Unfortunately,
My time is
we've
up.
gone way past the 15 minutes, and I'm sorry, I should have said something. I should have.
All right, well, I thank you for your
Is there
time.
anything else you want to say? I'll give you a minute if you want to wrap up.
No, if you don't have any other questions, I'll leave it at that. All right, thank you.
That case will be submitted. Now, moving on to the remaining cases, we have only one person endorsed for argument in any of the remaining cases. So let me call them one by one to see if anybody's here. Case number 11 on the docket. This is docket number 369666. In re S. Kate Pierce Minor. Ah, you must be Mr. McDonald.
Must be.
How are you, Mr. McDonald? Good to
I'm
see
well.
you.
Good afternoon, Your Honors. May it please the court, Timothy McDonald. I was appointed as a special prosecutor in this case, probably about 5 years ago, due to a conflict with the local Livingston County Prosecutor's Office to represent the petitioner appellee DHHS.
Ah, okay.
There's a long-winded appearance.
Yeah, you are the appellee in this case.
That is correct.
And so you don't have to necessarily persuade us of anything, but we'll be glad to hear whatever you want to tell us.
Well, I think just for our purposes, I would seek to ask any questions if there are of the panel. I would start there. Okay, then what I would like to say is that in the history of this case, as I said, it's been going on for more than 5 years. And it's a 5-year-old case of a complaint that you're not helping me out, you're not providing me services.
You're talking about the ADA component.
Yes, and there was this fella, he's from California, Jay Shore, non-attorney. He just pops in, he's one of those advocates that is her advocate, to which her own attorney said, hey, I'm not doing that right now because she's doing it with this other fellow. It wasn't a case where the attorney failed to make an argument, failed to object. He made an affirmative statement on the record that this is all being handled by her ADA coordinator. And so, and also what I thought, just a bit of maybe it was a little disingenuous in the appellate brief, is that they say, well, she didn't have her rights protected because her attorney was disbarred. Well, that particular attorney, Jennifer Payne, was disbarred in 2022, August. Then she had court-appointed counsel. I think she had another court-appointed counsel. Then she got retained counsel. For 3 years, none of these issues seemed to come up, and she's blaming her attorney who was off the case. Now, she was disbarred not because of this case. So I think a lot of the arguments get down to, we just have somebody who has it's already been adjudicated of the drug use, the criminality as impediments to safe parenting. She, by her own admission, was an addict, is an addict, will always be an addict. And then again, the other thing I like to highlight is that when there's you're not obeying a court order. Well, the order she didn't obey was the big one. You are ordered not to have contact with this individual. And that is just set aside like no big deal. I've been doing this 30 plus years, and I can't tell you that I've ever argued on a no contact order, which if it were a criminal case, that would, if it was a bond violation, you go to jail. If it was a probation violation, that's non-technical. If you can do a lot of things and you could maybe disobey an order here and there, but when you have a no contact order, you're told no unsupervised contact, and that's just brushed off. Also in the record, now I think I've got about 42 transcripts with this case, and I've lived it, so it's kind of easy to have recollection. But the problem we had is that this was going to go for termination a while ago, and we backed off at the department and said, hey, let's give you one more chance. And that was just included, even when we said, look, we know you, now she didn't miss a drug test or fail a drug test. We had drug testing coming to her. In the record, her failure of drug tests or missed drug tests were actually in the hundreds. And so I don't know what conceivable services she could have, what disability, the disability of an addict. Well, that's not, that doesn't carry the day. I'm a drug addicted addict. I can't get off my drugs. I can't get off substances. Her attorney came to more hearings than she did. And the one where she complains her rights were violated because she couldn't testify. Her attorney told her, first of all, she was supposed to be there, didn't come there, came by Zoom. Her attorney told her, don't talk. So if her attorney is telling her not to talk, I wouldn't say that Ms. Drosis, if any time she was dissatisfied with his better than a year or more of any type of representation, could have dropped him off and picked up another court-appointed attorney. So it just all the arguments that are in there, I don't know what else the department could have done. And also if she has an ADA claim, like I didn't mean to be facetious or take a negative tone,
Sure.
but the distance between the ADA rep office is from the courtroom is from that table at the end to this table. And in the middle is a sign that says, this is your ADA coordinator. And they would have to have firmly made a decision. We're not going to go in there and check and see what's going on as we walk back and forth in front of that office time after time after time. So
Yeah.
I just asked the court to recognize that the department has done all they can in this case. And when it's coming to the best interest of the child, that is just back to that 0.5%. This is all about what's good for mom. And the department has to do what they can to protect children. And this is the kind of case that would do that. And I'd ask the case, the lower court be affirmed.
Thank you very much, Mr. McDonald. Anybody have any questions?
I don't.
Okay, thank you very much. Thank you so much
Thank
for
you.
your patience today.
Oh,
Sorry
no,
you were
that's
at the end
okay.
of the call.
That is fine. No problem there. It was just enjoyable to just sometimes as an attorney after doing it for a few decades, sometimes it's nice to just sit and watch proceedings, because one thing I've learned is that, to say learned again, is sitting in a courtroom watching things, you're gonna, I took a note or two. So
Oh, yes.
you're always, but the case that you mentioned, it doesn't matter.
Right.
Law, if it was a statutory
Right,
environment, I was nodding along, yeah, it doesn't matter if it was a law, breaking a law, refusing a law, a law that was changed and all that. And it's kind of nice to be here and see everybody.
Well, thank
Well,
you so
and
much. Oh,
I think you'll find after, with these next cases that get submitted on the record, we very rarely have attorneys come with, and present argument for termination of parental rights cases, despite their huge import that you mentioned in your oral argument. So I really appreciate you being here today. It's incredibly helpful, speaking for myself, for my own learning and understanding of the case and its circumstances. So
Well,
it
like I
means a lot.
said, it's been going on for 5 years.
well, but hey, Judge Young is right. You really are the exception, not the rule. We so infrequently see attorneys appear in these.
Well,
cases.
I think it's because I'm not under the auspices of a regular prosecutor's office, because I have my own practice in Howell.
Right.
So maybe, and this is the second time I've been in front of the panel. The first was Zoom on this case. So this is the second time around, but it was for the other parent. So I did the Zoom, but so as it all goes, I think it's just, I just cleared my schedule. I didn't have to ask my boss. So I just feel so strongly for the case of what's been going on, and we've been, we've tried everything. And so it is what it is. So I didn't think it would be appropriate to not show up.
Thank you.
Thank you so much.
All right, thank you.
That case is submitted. We'll move on to the remaining cases on the docket, none of which has any attorney endorsed for oral argument, nor is there anyone left to argue in the courtroom. Two cases are consolidated as our case number 12, docket number 373399, and docket number 373462. The former is In re Brannick Van Blaricum minors. The second one is just In re Van Blaricum minors. Those two cases are submitted without oral argument. Next is case number 13 on the docket number 374553. That is In re Campos Palacios minors. There's no one here to argue that, so that case is submitted without oral argument. And then finally, the last case on today's call, number 14, is docket number 374559, In re J.D. Fowler minor. No one is here to argue that case, so it's submitted without oral argument. That concludes our call for today. As I indicated at the very beginning, we'll be back again tomorrow at 10 o'clock to resume the case call for panel number 6. Thank you very much, and we can stop recording.